everyone, and welcome to Crime in Court. This is the 1996 Menendez brothers trial, and we are reading through the transcript because unfortunately we don't have video. Erik and Lyle Menendez are on trial for the homicides of their parents, Jose and Kitty. Their self defense is that they were protecting themselves from Jose and Kitty. This is their second trial. The first trial ended in a mistrial, and we are on part 14 of the state's case, and we are going to read over Mark Heffernan's testimony. So, with that in mind, let's get started. And let me shrink myself here. Up first, I just wanted to remind you of who the key players are in this. And I like visuals, so I put together a visual for you guys. And this is available. If you go to the Menendez Brothers court document Google file or Google Drive that I created, it is the MB Trial 2 attorney slideshow. So Gil Garcetti is the prosecutor. He is the DA for Los Angeles County District, and he was overseeing the prosecution in both the 93 case and the 96 case. But we don't hear from him really. We hear most of it's done so far by Carol Nahara. I've been saying Nahara, and she is currently a um, Superior Court judge. So she went from deputy DA to Superior Court judge in her career. David Kahn is he passed away at the age of 56 in 2017, but he is the other prosecutor. He was the other like deputy DA or whatever from the Los Angeles DA's office. Then we have that was all the prosecutors. Mostly we're hearing from David Kahn and Carol Nahara. Then we have for Lyle's defense, Michael Judge is admitted as an attorney for him, but I don't think he's actually practicing in the courtroom. So who we are getting from his team, I guess, would be this Charles Gessler and Terry Towery. She's currently retired, and Charles Gessler unfortunately passed away, but he lived to a ripe age of 85. So I guess that's not so unfortunate. Um, And then, of course, we have Leslie Abramson, who has been listed as inactive as a public defender since 2023. But she's been, ever since the Menendez cases, she was still litigating as a public defender. So she had a long career. All right, Eric's defense also included Barry Levin. So Leslie and Barry together on Eric's team, and Terry Towery and Charles Gessler on Lyle's team. And then, of course, we have good old biased judge Stanley Weisberg, and his whereabouts are currently unknown. But he was the judge for both trials. He also presided over the Rodney King trials, and he retired in 2008. So, kind of an interesting little some interesting little tidbits about who and where they are now. All right, so where are we now within the court transcript? So this I have put together for you, the testimony list of all of the witnesses. We are currently on week 3, Mark Heffernan, tennis coach. And you guys have determined that a poll is not even necessary. So, can I delete? Let's just hide the column. So we're going to go over everybody's testimony. So we haven't skipped anybody so far. We've been reading through even the arguments, and you guys wanted that, which I totally get, and you get a lot of context. So it's very helpful. We didn't have the sidebars and things like that to listen to or learn about what the rulings were in the first trial. So this time it's a little more interesting hearing the conversations outside the presence of the jury. All right, so let's get to it. Where is it? Here it is. Sorry. All right, so we are on, like I said, October 24th, if you are following along with the transcripts. And we're just going to start at the beginning. So the court says, okay, in the trial, we have everybody here. Is there something that you want to talk about before we get started? Ms. Abramson says, just briefly, Your Honor, with respect to the first witness today. With respect to the first witness today, who is Dr. Mark Heffernan, two things. I did not know Mark Heffernan was a doctor. I want to make sure that the people are not going to try to elicit things that the court has previously ruled are inadmissible, specifically the statements that Dr. Heffernan had made to Erik Menendez on the plane when they were flying back to London, to which Erik made no reply. This has been litigated in the past and was ruled in the court not to constitute an adopted admission, and I want to make sure the people do not stumble on that. And the second thing is, I showed Ms. Nahara this morning some of the documents I wanted to show the witness that were shown to him before the 402 hearing in the first trial, and she is objecting to my using these documents. So those are the two issues. The court says, which documents are those? Ms. Abramson says, they are listed of dates that the coach, Erik Menendez, they are listings of dates that he coached Erik Menendez in 1989, and they show the number of hours and they show the total charges. Okay. Well, on the first issue, then, what is the people's position? You intend to get into that? Ms. Nahara says, my understanding, Your Honor, is if counsel is referring to the statements where Mr. Heffernan discussed Mr. Menendez's guilt and Mr. Menendez said nothing in response to it, no, we would not be getting into those statements. The court says, okay, and as far as your objection to the records, what is your objection to that? Ms. Nahara says, Your Honor, Mrs. Abramson explained to me that these, in fact, were records of bills to Mr. and Mrs. Menendez from Mr. Heffernan for services rendered. I asked Mr. Heffernan about these particular statements, and he told me that, in fact, he believes that he did not, on most occasions, bill Mr. and Mrs. Menendez. What he did was simply told them originally that they owed, and at some point later, they needed some bills, and they made these bills up after the fact. And he quite frankly says that he is not sure that they are even accurate. He has some dispute with the amount that he charged on them that might have been different from the amount he actually charged them. So I believe there can be no adequate foundation laid for them. Ms. Abramson says, well, my understanding from his testimony last time, the main interest I have in the number of hours per period of time contained on these sheets that he was coaching Erik Menendez in 1989. The court says, well, what I will do is see if you can establish a foundation. Damerson says, right. The court says, I don't see that it needs to be done outside the presence of the jury. If you can establish a foundation, it's clearly relevant as far as the issue that the people raised, as far as the amount of money spent by the defendant for his activities after the death of his parents. So this is the specific amount. If it can be established as a specific amount, then it would be admissible. Ms. Abramson says, thank you, Your Honor. Ms. Nahara says, thank you, Your Honor. The court says, Mr. Gessler, were you going to say something? Mr. Gessler says, we also have the 402 motion pending whenever is a convenient time to do it before Detective Zoller testifies. So Detective Zoller is coming back. He comes back to the stand multiple times just to give you warning. So his testimonies, even though he testified and it went on for days and it was concluded, because he's the lead investigator, they bring him back several more times for little things to clear up stuff on the stand. The court says, I hope to do it this morning, but I got tied up with something else. So we will see if we can fit it in today if we have the time. Do we have the jury here? The bailiff says, jurors are on the way, Your Honor. The court says, any other matters you want to talk about before the jury arrives? Ms. Abramson says, there is going to be another issue with the witness today, Mark Slotkin. Mark Slotkin does not testify today. So again, here we are with all these different witnesses that the state wants to put on and they never get to them. So for this particular day, the only people that testify are Mark Heffernan and Amanda Geyer. So Mark Slotkin is listed to be a witness on this particular day, and he never even showed, like, he's not even called. They have a really bad habit of doing this to the defense. We're 3 weeks in, and they keep doing this. Like, every day, it seems that their witness list changes. But anyways, she says there's an issue with Mark Slotkin. Mr. Levin, if you want to take that up now, Mr. Levin says, would you want to, Your Honor? The court says, go ahead as long as we're waiting for the jury. Mr. Levin says, what I would like to know from the prosecution is an offer of proof with respect to the issues they are going to attempt to elicit from Mr. Slotkin. It's my understanding, based on previous court rulings, that Mr. Slotkin will only be allowed to testify to the spending with respect to Erik Menendez relating to a Lake Tahoe trip, and if there is anything other than that that the prosecution wishes to elicit. We are then requesting a hearing. I don't want to take up any court time if they're not going any further than that. The court says, well, who is calling him? Ms. Nahara says, Your Honor, for the record, I had an informal discussion with Mr. Levin before Your Honor took the bench, and I told him at that time that the only evidence, to my understanding, that the court would allow is the spending evidence from Lake Tahoe. So I will put that on the record, and that is what I told him earlier. Mr. Levin says, very well, Your Honor. What we were concerned about was just the extent of the testimony, and that being the case, we don't need to address it. The court says, okay, any other issues? Who is up after Mr. Heffernan? Ms. Nahara says, we're hoping, Your Honor, either Ms. Geyer or Ms. Hart. Court says, okay, are they here? I believe we're expecting one now, and I believe one is down there. Court says, okay, how long do you think Dr. Heffernan's testimony will be? Ms. Nahara says, an hour and a half. That's including cross. Ms. Abramson says, perhaps. And then Ms. Nahara says, unless. Ms. Abramson says, that doesn't sound unrealistic. Court says, okay, all right. As soon as the jury is here, we will start up. Ms. Abramson says, Your Honor, there may be some questions with respect to Mr. Heffernan that, although relevant to the prosecution's theories, may be slightly beyond their precise direct. Since Dr. Heffernan is employed by the hour and it's cost him a great deal of money to be here before and be here again, I would like leave of court, and I am sure Mr. Gessler would as well, to be able to ask a few questions that are significantly beyond that so that we don't have to call him back. The court says, what is that? Ms. Amerson says, it just has to do with, for example, he was present when Lyle Menendez purchased the camcorder, which seems to be a feature of the prosecution's motive evidence, and he knows the purpose when it was purchased, who was there, the purpose for which it was purchased, and so testified at the last trial. I am not sure of all, since he has information about a number of different topics, I am not sure how many of those the prosecution is intending to get into, but that's one thing they may or may not get into. I don't know if they're going to get into the fact that he was with Erik Menendez in Israel. I think that they wanted to prove that up as a spending component, but he doesn't. I am not aware. Maybe we should bring this up now. I am not aware of any spending aspect of that trip to Israel that the people have in their arsenal, if you will. If he was indicated that if he has indicated what things cost, I am totally unaware of that. And the court says, well, he is being paid, I assume. Ms. Abramson says on his contract, and the fact that he is being paid has never been a problem. That was testified to in the first trial, and that goes without saying. It's just whether what it cost Erik to do it, I suppose, is the spending component or what his costs were. I don't know the answers to those, and I don't know if the people do, and if they do, I'd like discovery of it now. The court says, okay, what else? Anything else? Ms. Amerson says, well, as I say, there is a number of topics. As the court knows, he was called by our clients right after the 911 call. I don't know if the people intend to get into that. He was at the police station and was interviewed by Detective Edmonds. I would want to bring some things out about that briefly. I don't know if the people intend to do that. He will testify that he was not at the home nor giving a lesson to anybody on Saturday, August 19th. I don't know if the people intended to go into that. I also would want to ask him questions about Eric's ability to concentrate both before and after the deaths of his parents. The court had indicated with respect to other witnesses, even such as Herb Doss and Norman Poles, that the kind of evidence close in time to the homicides was admissible. The court says no. I said if it was tied in through the testimony of the psychologists who testify, if they do testify. Ms. Abramson says, well, I'd rather not have to bring this witness back to just say that. He said it at the last trial as well. The court says, but we can get into that with every witness that you might be calling on other witnesses. Ms. Abramson says, well, if it's so pervasive and a symptom that everybody sees it, I don't understand why it's got an admissibility problem, particularly someone who is working with the client in the area that requires the last word I said was requires. The next word would have been great concentration. I think it's admissible. But beyond that, Your Honor, it seems to me the people would even want to elicit that because obviously my client's demeanor and emotionality after the homicides is relevant since the people are claiming that his spending of money is evidence of some cold blooded motive. I think I should be entitled to show how distraught and emotionally upset he was for a long time after the homicide, since it is at least con. Com- I don't know how to say that word. It happened together with the spending evidence, which has not been stretched to February. They are allowed to bring in evidence to that, and Dr. Heffernan was with Eric Menendez when he was in Israel. The court says, you are talking about two different things. Ms. Amerson says, but the people may want to show that he had concentration problems before. The court says, we're not talking about what the people want. We are talking about what you want. Ms. Abramson says, well, I would like to be able to ask that question and not bring Dr. Heffernan back later in the case. The court says, well, it all involves also cumulative evidence, even if it is admissible, as to which witness you would be entitled to bring in. You talk about other witnesses you want to bring in for the same subject. Ms. Abramson says it may be the same subject, but it's not the same time period and not with regard to the same activity. Here is someone right before the homicides working with my client. There is no other witness as to what time period. The court says, I am going to hold off ruling on that as to whether it's going to be allowed now or later on. At this point, it is not relevant. As to whether or not it is relevant in the defense case, at this point, I am just dealing with some issues that relate to the direct examination and more controversial issues that you might be bringing out on cross, so we don't have to interrupt the examination. But we now have a jury here, so we will just start up with the testimony. Let's get the jury out. So what is the resolution? Like he didn't even resolve the thing. The jury entered the courtroom and the following proceedings took place. Okay, we have the jury back. Good morning. Okay, we're ready to start up. The people may call their next witness. Ms. Nahara says, thank you, Your Honor. The people call Mark Heffernan. Mark Heffernan was called to the stand and he's sworn in and he spells his name and all that stuff. All right. Ms. Nahara says, sir, back in 1988 and 1989, what was your occupation? I was a tennis coach and a psychotherapist. Oh, that's where the doctor comes from. He was a tennis coach and a psychotherapist. The court says, would you move a little closer to the microphone, please? Ms. Nahara continues, and prior to 1988, how long have you been a tennis coach and psychotherapist? A tennis coach about 8 years and a psychotherapist 3 years. Now, sometime before August 20th, 1989, did you meet a family that you identified as the Menendez family? Yes, I did. And were you hired to do something for them? I was hired to coach tennis. And who? Ms. Abramson says, Your Honor, I cannot hear the witness. The witness says, I was hired to coach tennis. Ms. Abramson says, thank you. Ms. Nahir continues, and do you remember who hired you to coach tennis? I think the boys originally made the decision and then the parents went along with it and hired me, actually. They are the ones that made the final decision. And when you say the boys, can you identify people by their name? Erik and Lyle. And would that be Erik and Lyle Menendez, the defendants present in this court? Yes, it is. Okay. And you said that at some point, Mr. and Mrs. Menendez, Jose and Kitty, hired you to teach them. They did. Now, do you remember when they hired you to coach the defendants? I guess it was the fall of 1988. Is that correct? Well, I'm asking you. It was the fall. I am not exactly sure of the time. I think it was the fall of 88. And did you coach them up from the fall of 88, excuse me, from the fall of 88 to the day of the time of the homicides? Yes, I did. Objection with respect to the use of the M word. And the court says, okay, that answer is stricken. The time of the homicides, the KI double Lings, yes. So I guess KI double L is okay, but the M word is not. I don't know. I guess the M word implies that the defendants were the ones who did it, but why not the K word too? I don't know. Anyways, so she says yes. I'm sorry, he says yes. The witness says yes. Now, sir, going back to August 18th, 1989, 2 days before the defendants took the lives of their parents, do you remember? Ms. Abramson says, Your Honor, I would object to the form of the question. The witness has no personal knowledge of those facts. Sustained. Going back to the August 18, 1989, what were you working on that day? 2 days before the homicides? Yes, I was. And were you working at the Menendez house? Yes, I did. And what were you doing on August 18th, 1989? I taught them tennis in the morning. I can't remember if I taught Erik or Erik and Lyle or just Lyle. I worked a couple of hours, I believe, that morning. Okay, and when you say that morning, about what time did this take place? According to what I said last time in the transcripts, I think between 9 and 9:30 I started. Ms. Abramson says, Your Honor, I would have to object to that according to what he said before. The court says, objection sustained. The answer is stricken. Rather than what was in the transcript, use your own recollection. The witness says, I can't remember. My recollection is I can't remember the exact time. Ms. Nahir continues, do you remember if it was the morning, the afternoon, or the evening? I think it was in the morning. And that morning, what did you do with regards to your profession of teaching tennis? I have no idea. It was different every time. And so you sit here now. Do you remember whether or not it was both the defendants or one defendant? What do you remember? I don't recall. Probably at the time, I think I was working with Erik more, so I would imagine I was with him. And how long did you work with him? How long did you work with the defendant, Erik Menendez, on August 18th, 1989? I imagine it was 2 hours. Now, from that day, August 18th, 1989 to August 20th, 1989, after the tennis lesson, did you see the defendant, Erik Menendez? No, I did not. And on August 20th, 1989, did you receive some information about an event at the Menendez house? They called me. When you say they, who are you referring to? Both boys, Erik and Lyle, I'm sorry. So are you talking about the defendants, Erik and Lyle Menendez? We are. And did you go to the police station on August 20th, 1989? No, I think it was August 21st. By that time, we went at 3 in the morning, 2 in the morning. Now, at some point, did you learn at some point that Mr. and Mrs. Menendez's lives had been taken? I did. And did you learn that night? I learned it that night, yes. Now, at some point after Mr. and Mrs. Menendez's lives were taken, did you see the defendants, Erik and Lyle, again? That same day? Just any time after. Oh, after. Ms. Abramson says, Your Honor, I'm going to object. I think the question is vague. Court says, are you talking about after that night, after August 21st? Did he ever see them again? Ms. Nahara says, after August 21st, 1989, did you see the defendants Erik and Lyle Menendez again? I did. And calling your attention to the defendant Erik Menendez, did you see him again in New York? Yes, I did. And Ms. Abramson says, I'm going to object. The witness says, sorry, the objection is what? To leading, and it's overruled. Ms. Nahara says, and do you remember when it was after the homicides of Kitty and Jose that you saw the defendant Erik Menendez in New York? I presume it was the first or the last week in August because we were at the US Open and it's usually the last week in August and the first week in September. I believe it was the first week of the tournament. And what is the US Open? It's our national tennis championship. And how did you come to see the defendant Erik Menendez at the US Open? Well, I was at the US Open watching the matches and going to the United States Tennis Association National Coaching Conference, and he was there and we arranged to meet. When you say he was there, you mentioned a couple of things. He was in New York or at the tournament, and I imagine he called my wife and I at our hotel. And did you arrange to meet him in New York? After he called me there, we hadn't in advance. I think he had mentioned in advance that he was going to be in New York, and I said, if you are there, call me, so he did. And after he called you, did the two of you meet? We did. And sometime after that, did you have a discussion with Erik Menendez about resuming his tennis? Sometime after that. And how soon after meeting him at the US Open? Ms. Abramson says, well, I'm going to object to the form of the question. The witness hadn't said he met him at the US Open. Sustained. Sometime after meeting him in New York. Well, let's go back. How do you know that the defendant Erik Menendez was at the US Open? I met him. So you met him physically at the US Open? I met him in New York. I think I met him at our hotel, if I remember correctly. Did you talk to him about the US Open with him? I am sure I did. What did you tell, or did he tell you whether or not he was attending the US Open? Ms. Abramson says, objection, Your Honor, hearsay, no foundation, no discovery, overruled. I think we talked about matches, yes. Ms. Nahara says, and sometime after you had this meeting with Erik Menendez, did you talk to him about, or you said you talked to him about resuming his tennis career? Do you remember when that was? No, I do not. And at some point, did you have a discussion with Erik Menendez about developing himself as a professional tennis player? Yes, I did. And about how long after the New York meeting was this? I can't say. Those dates have flown together and I am sure it was within the months after that. And did you start working with I'm sorry, with the defendant, Erik Menendez, as his tennis, blah, blah, blah. And did you start working with the defendant, Erik Menendez, as his tennis coach again? Yes, I did. And how did that come about? Initially, Erik and Lyle and I, the defendant and I, sat down and talked about what we were going to do as far as their tennis careers, and we came to some preliminary arrangement. Okay. When the three of you sat down to talk about, did you say resuming their tennis career? Did I write that down right? Or continuing them? Yes. And you said that was about a month after the meeting in New York? I guess so. I am not exactly sure of the amount of time. So this would be September or October of 1989? That's correct. And what did you discuss at the meeting with the defendants and yourself? Generically, where they were going with their tennis and what they wanted to do. I am not exactly sure what else went on. I am sure we talked about at least those two subjects. And did you talk about other subjects at that meeting? I cannot recall. At some point after that meeting, did you have a further, more specific discussion with them about their tennis careers? I did. And about how soon after this first meeting in September, October of 89, did you have another meeting with them? I'm not sure. I don't know exactly what time. Would it have been a week later, a month later? Ms. Abramson says, I would object, Your Honor. It's calling for speculation since he doesn't know. The court says he can try to pin it down a little bit. Objection overruled. The witness says, I would think it would have been within a month. Ms. Nahara says, and within a month, did you have a discussion with both defendants, Erik and Lyle Menendez, and their aunt Marta? And what did you discuss? Terms of a contract that was going to be drawn up. And what was the contract to be about? Terms of the contract were length of time, quality of the days, what we were going to do in the course of a week in our training, how extensive it was going to be, how much money I was going to be paid, things of that nature. And what was this contract for? I guess both their and my protection as far as maintaining the integrity of the contract. Now, with regards to the contract, what is it that you are going to be providing the defendants? Sports science coaching. And would you be providing this to both defendants or one defendant? Both, with the possibility of modifying that to one later. Lyle, at the time, wasn't sure if he was going to continue or how arduously he was going to continue. And how long was the contract to be? What was the length? A year. 1 year? Yes. And how much were you to be paid for the year for providing sports science coaching? I believe I was to be paid $5,000 a month for one of the defendants, and if I worked with both, then $6,000 a month. And the one defendant for sure that you would be working with would be Erik Menendez? Yes, it would. And at some point, did you finalize this contract? We did. And when was that? I'm not sure. I didn't look at the dates. Before you finalized this contract, were you providing sports science tennis coaching to either or both defendants? I was. I was providing tennis coaching more. We were going to do a more comprehensive program after that. So when you say you were providing tennis teaching, how long before the contract was finalized were you providing tennis teaching up to the time that it was finalized? Yes, yes. Ms. Nahara says, and Your Honor, I have what has previously been marked as 188. I would like it marked Exhibit 122. This appears to be a contract. I have shown it to counsel previously. Court marks it 122. She says, that's it. And may I approach? Yes. Showing you what's been marked Exhibit 122 for identification, would you look through those papers and tell me if you recognize what I've placed before you? That's the contract, I believe. And by saying that's the contract, is Exhibit 122 the contract that you entered into with the defendants? Yes, it is. And did you enter into this contract in January of 1990? Yes. And were you providing them with tennis coaching up to January of 1990? Yes, I was. And do you remember when you start providing them with tennis teaching or tennis coaching immediately after their parents lost their lives or sometime afterwards? Sometimes afterwards, I think there was lag time there because of the events. And do you recall when it was that you started up with your tennis coaching? No, I do not. After the No, I am not exactly sure when it was. But you recall that it was that you were coaching tennis, you were coaching the defendants their tennis game before January of 1990. Yes. And sometime after August of 89. Yes. And is that time period sometime after August of 1989, August 20th, when Kitty and Jose Menendez had their lives taken, and before you entered into the contract of January of 1990, were you coaching both defendants or one? I was coaching both of them, but irregularly. Now calling your attention to this contract and specifically to page 1, if I may, on that it says something about compensation. Is that right? That's right. And the figure there is, well, what is the figure there? 6,000 per month. And how did that figure enter into your negotiations? How did it enter into the negotiations? Yes. How did it enter into the negotiations? The court says, do you understand the question? Ms. Abramson says, objection, I think it's a vague question. The witness says it is a vague question. Ms. Nahara says, let me ask you a different question altogether. Do you remember whether you were paid $5,000 a month or $6,000 a month? I was paid $6,000 a month for the first 4 months or 3 months, I think, because I was working with both boys. And then at some point before Erik and I went to Israel, Lyle decided he was going to pursue other ventures, and I was going to work with Erik with the possibility that Lyle could come back at any time. So you started out making 6,000 and at some point it went down to 5,000. Yes. Do you recall when that was? Just before I went to Israel with Lyle or Erik, or with Erik. He went with Erik. He didn't mean to say Lyle. And do you recall what month that was? We went in February of that following year. Now, when you went to Israel, did you go with the defendant, Erik Menendez? Yes, I did. And what did you go for? To play the Satellite Pro Tour in tennis. And when a tennis player goes to play this kind of tour, do they have to pay some kind of an admission fee or an entrance fee? Yeah, they pay the entrance fee. And how much was the entrance fee for the Pro Satellite Tour? I'm not sure. I believe that Erik took care of that. I wasn't in charge of the fees at this time, but I don't really know what the fees were. They're not too high. And with regards to the expenses of flying over there, who paid for those? The defendants, under the terms of the contract, they paid. And by that, I mean the airline tickets. Who paid for the airline tickets? They did. By they, are you referring to the defendants? And who paid for the living expenses in Israel? They paid for all of my expenses. And where did you stay while you were in Israel? Hotels. We stayed in Ashkelon, Haifa, and we just were arriving at Tel Aviv. We were actually in Tel Aviv for a day or two, a day, I believe, when I came back. I missed the first place you said. I missed the first place you said you were. Ashkelon. Ashkelon, yes. And there are cities, I take it? These are cities? Yes, these are cities. So you went on to Haifa, I don't know how you say that, and Tel Aviv. Yes. How long were you in Israel? A little over 2 weeks, I believe. And were you staying, I take it, you stayed in hotels the whole time, not in people's homes. We stayed in hotels, except for the last night we were there. We stayed at a family friend of the defendants, an old coach, if I recall, and we stayed with him one night, he and his wife. And when you were staying in Israel, who was paying for those hotels? The defendants. Do you remember how much they were that per night? No, I do not. And who was paying for the meals? The defendants paid for everything. And with regards to the defendant, Erik Menendez, did you observe him purchasing various objects after his parents died? Ms. Abramson says, Your Honor, I'm going to object to this and ask for an offer. It's beyond the scope of the 402s. The court says, all right. Do you have some other issues here other than this that perhaps you can go into? Ms. Nahara says, the last group of issues, Your Honor, would deal with this subject or related subject matter. He says, okay, all right. Well, what we'll do is ask if you can just go into the jury room for a moment and I'll talk to the lawyers and have you come out. The witness says, should I stay here? Yeah. Jury exits the courtroom. The court says, and what was it that you intended to elicit, Ms. Nahara? Ms. Nahara says, Your Honor, yes, this was elicited at the first hearing on this matter, and basically it was his spending practices. Apparently, his witness testified that he noticed that the defendant, Erik Menendez's buying practices changed after the death of his parents. He would buy what he wanted. He spent money on a much larger scale, and that is basically it. And he bought a pool table and a Jeep for himself. All of this was elicited in the first trial. Ms. Abramson says, but none of it was proffered, Your Honor. when we were going through this joint trial, all of the litigation of what they wanted to bring out with the spending from these witnesses. And it is my belief, although the witness is sitting here, that this witness does not have figures for any of that. And before, this witness was given statements before that he felt that both defendants had plenty of money before, wanted for nothing, and thought it preposterous that the prosecution had a theory that they took their lives for money. So, if they want to get into spending practices, I want to get into his conclusions. The court says, well, his conclusions are not relevant or admissible, but the issue here is what evidence you wanted to introduce. I don't recall this being raised during the people's proffer of evidence, Ms. Nahara. Ms. Nahara says, it wasn't, Your Honor, but this isn't actually spending evidence per se. Some of it, the Jeep, has already been ruled on, but basically, this is practice. He observed buying practices, and we did. The court says the reason we have these hearings before the trial is so we can litigate these matters and we don't have these interruptions. And we have the notice to the other side of what you intend to offer. So this is, for once, he's actually like kind of reprimanding the prosecution, but not really. Not really, because nothing's going to come of it, but he's at least saying, like, this is why I wanted you guys to litigate this in hearings before trial because I don't want these interruptions. So stay in your lane. He says, you said you wanted to offer the trip to Israel and the contract. Ms. Nahara says, and anything that was controversial with regards to the jury, and this harkens back to what we stated before, that every single line we were not going to litigate in the proffer, and if the defense has specific objections to certain things, it is incumbent upon them to make those objections. They have as much access to these transcripts as we do. This is not a major spending issue, but his buying practices were something that were elicited in the first trial. I don't know why they wouldn't think it would be elicited in this trial. And everything we are going to elicit, sentence by sentence, was not litigated, Your Honor. And my understanding was that it was not the reason for all the litigation that we did. That was a lot of nothing. Court says, but there was notice of new spending evidence that the people intended to offer and things of that nature, and we did have litigation on that. And the court was of the view that what you were offering as to this witness was, as we discussed it in the initial evidence. Ms. Nahara says, so the court understands this isn't new spending evidence. This is simply the statements that he made that the defendant, Erik Menendez, spent more money after his dad passed away and his buying practices changed after their deaths because he could buy whatever he wanted. The court says, I will permit you to ask the question right now and see where it goes. Ms. Nahara says, okay. Mr. Heffernan, so again, this is outside the presence of the jury. Mr. Heffernan, after Jose and Kitty Menendez had their lives taken, did you observe that the defendant, Erik Menendez's buying practices changed? Ms. Abrams says, and I would object, Your Honor, that there was no foundation that the witness was aware of his buying practices before. The court says, we will do one thing at a time here. If he answers no, that would sort of corroborate your objection in one fashion anyway. You can answer that. The witness says, well, he bought a car, and I think he had the opportunity to buy what he liked. He bought a car, and I didn't see him buy a car before the homicides. Really? That's your go-to? Well, he bought a car, and he didn't have a car before, so it must be that he's guilty for that reason. So stupid. Ms. Nahara says, did you observe that he would spend a lot more money on a larger scale after his parents died? Ms. Abramson says, calls for speculation, Your Honor, overruled. Witness says, well, I guess a lot more money would be in the form of a car. He bought a pool table for himself. I think they rented furniture. So he was having to provide for himself now, so I think he spent money on a larger scale, yes. Ms. Nahara says, and basically that's it. Your Honor, that's all we're going to elicit from this witness. The court says the car is a Jeep? Yes. The court says, I will permit you to ask questions about the Jeep, and that's it. Ms. Nahara says, okay. Ms. Abramson says, I'm sorry, Your Honor, I couldn't hear what you said because my client was talking to me. Court says, I said she will be permitted to ask questions about the Jeep and nothing else. That will be it. The court says, let's get the jury back. And Ms. Abramson says, Your Honor, before we bring the jury back in, could I run into the back hallway for 1 minute to use the ladies' room? The court says, okay, hold on 1 second. Brief pause. How long is this hearing involving Ms. Maher going to take? So now we're on a hearing for Ms. Maher, or continuing from the conversation from when she was on the stand. Anyways. So again, the court wants to know how long the hearing involving Ms. Maher is going to take. Mr. Levin says 40 minutes. The court says, and Detective Zoller will be testifying. Ms. Nahara says, yes, Your Honor, it won't take more than 15 minutes, 20 minutes at the most. The court says, okay, let's get the jury out, please. The jury enters the courtroom and the following proceedings were held. The jury is back and you may continue your direct examination. All right, so that's continued. Ms. Nahara says, thank you, Your Honor. Now, sometime after Jose and Kitty Menendez's lives were taken by the defendants, Ms. Abrams says, object to the form of the question, Your Honor. Okay, again, sustained. Like, how many times is she going to do that? And she's a judge now, guys. She's a judge now. The court says, okay, sustained. Ms. Nahara says, did you? The court says, wait. The objection is sustained. Ms. Nahara says, after August 20th, 1989, strike that. After you came back from New York, you saw the defendant, Erik Menendez. Is that correct? Yes, I did. And at some time after you came back from New York, were you aware that he had purchased a new vehicle? He had purchased a new vehicle. And what did he purchase? He purchased a Jeep. And what kind of Jeep was it? I'm not exactly sure of the brand, sort of a squarish convertible with an add-on top. And do you remember when it was that he purchased this Jeep? Not precisely. Was this after August 20th, 1989? Yes, it was. Was it before you entered into your contract in January of 1990? I believe so. And sometime after August 20th, 1989, and before you entered into your contract in January of 1990, did the defendant, Erik Menendez, move into a new place? He did. And did the defendant, Lyle Menendez, move into a new place? Yes, he did. And where was this place? It was in Marina del Rey. And what was it exactly? It was a condominium complex. And was it referred to as the Marina City Condos? I think it was. And Your Honor, I have a photograph I'd like marked People's Exhibit 123, and it's been shown to the defense. Court says 123. She says thank you. And actually, Your Honor, I have a second photo of what appears to be some tennis courts, which I would like marked 125. 124. Court says, all right. Ms. Nahara says, and showing you what's been marked 123 for identification, would you take a look at the photo and tell me if you can identify what it depicts? Those are the 3 towers of this complex. Ms. Abramson says, I'm sorry, Your Honor, I couldn't hear the last part of the answer. The witness says, these are the 3 towers of this complex. Ms. Nahara says, and when you say of this complex, does that depict the complex that the defendants moved into after August 20th, 1989? I believe it does. And showing you what's been marked 124 for identification, do you recognize what it depicts in that photograph? Tennis courts. And did the complex depicted in 123 have tennis courts? It did. How many tennis courts? I don't recall the exact number. Those look like the courts that we played on. There were a few spread out, so I am not exactly sure of the number. I can't remember that. And does 124 appear to depict the tennis courts that were at the Marina City condominiums? Yes, it does. And with regard to that, were there both indoor and outdoor courts at the Marina City condominiums or just outdoor courts? Just outdoor courts. Now, sometime after January of 1990, I believe you testified that you went to Israel with the defendant. Is that right? That's right. And for this tour, did you have to basically make arrangements to be in different matches in different cities? Yes, I did. And how does that work? If you could explain that to us. Well, there was a tour of four different tournaments, and there is a qualifying tournament really, and then the top 16 qualifiers qualify into the tournament with 16 other people that have world rankings, the highest world rankings that enter the tournament really. So they determine who is going to be seeded and who isn't. And actually, there are seedings in the qualifying tournament as well. So Erik was in the qualifying tournaments. And do you have to fill out forms to participate in all of these different tournaments and things like that? Not just forms, really, just an entry, and entry form is very basic. And you also pay the entry fee, is that right? Yes, that's right. And with regards to all of these arrangements that were made, well, the arrangements have to be made to stay in various cities and make reservations at various hotels and all that. That's correct? And does that have to be done by the individual tennis player or is that done by the tennis tournament? No, nothing is done by the tennis tournament other than the tennis matches, as everything else is taken care of by the individual. So the individual tennis player has to make all of the arrangements. Yes, yes. And who made the arrangements for your going on tour with the defendant, Erik Menendez? They have to. They did the financial arrangements. So when you say they, who are you referring to? Erik and Lyle. We planned this in advance, and as far as the hotel reservations, I think the defendants made all of the arrangements. So when you say the defendants, who actually went on tour with you? Erik. So did the defendant Erik Menendez make all of the arrangements? I can't remember exactly how all the arrangements were taken care of. Ms. Abramson says that it would move to strike his previous answer, Your Honor, is beyond his personal knowledge, overruled. Mr. Harris says, and you did not take care of any of the arrangements, is that right? I'm sure I took care of a few of them. I'm just not exactly sure which ones they were. So the majority of them, who took care of them? Probably Erik. So this would be the defendant, Erik Menendez. Ms. Abramson says, Your Honor, it's really redundant at this point. We can all agree that Erik Menendez is a defendant, and I would object to counsel constantly using that phrase. Well, if there is an issue as to which defendant, then it's appropriate. So objection overruled. Oh my God. It is redundant. Thank you, Your Honor. And that would be the defendant, Erik Menendez. It would. Okay. May I have a moment, Your Honor? I think I'm about done. That's it. Okay. Any cross? Miss Abramson says, Thank you, Your Honor. So cross with Miss Abramson for Erik, for Erik's team here. Dr. Heffernan, how long were you and Erik Menendez supposed to be on this tour? Probably a month or 5 weeks. And how long were you actually on this tour? Half the time. We played two tournaments and what caused it. Okay, we played two tournaments, period, and stop. Sorry. Read too fast. Blah. Okay. And what caused you to end the tour before you were supposed to end it? Erik received a call that his brother had been arrested. Mr. Harris said, I would object to anything beyond the phone call as hearsay. The court says the answer will stand as recited by the witness. The next question, please. Ms. Abramson says, and after he received a phone call that his brother had been arrested, Mr. Harris says, I would object to any recount of any hearsay. The court says the answer stands, so the witness has given that answer. And your next question. Thank you. After Erik received the phone call about his brother being arrested, did he then make plans to come back to the United States? He did. And did you and he cancel the rest of the tour and book immediate passage to London? Did you not? He did. And from London, he booked passage to the United States? Yes. To Florida first, correct? Yes. And were you with him on that trip from from London to Florida? No, I was not. And do you know how he got from Florida to Los Angeles? No, I don't really. Now, under the terms, well, first of all, is it standard in tennis coaching contracts that if the coach is going to accompany the student to tournaments, the coach's expenses must be paid for by the student? I would say must be, but I would imagine they were, yes. Ms. Nahara says, I would object to the answer if he doesn't have any foundation. The court says, overruled, the answer will stand. Ms. Abramson says, with respect to your contract, that was a provision of your contract that your expenses for traveling and for being at these tournaments, your overhead, if you will, had to be paid for by the students. Yes. So the whole contract provided you with that a year. Or with what a year? The amount of money? Yes. 6,000 a month or 5,000, depending on how much time I spent with either boy. And it wasn't anticipated that you would be working every single month or 12 months a year. It would. So it would come out to something between 60 to 72,000, something like that a year. Yes. Did you consider that to be an enormous amount of money, Mr. Heffernan? Ms. Nahara says, I would object. It's irrelevant. The court says, objection overruled. Overruled. The witness says, enormous amount of money? No. Ms. Abramson continues, would it have been at all profitable for you to enter such a contract if you had to pay for all of your own expenses for traveling to foreign countries to compete? It would have been out of the question. Well, yeah, everybody needs to be reimbursed, for their time and whatnot. So obviously, if you are traveling with your coach and the coach is, why is that not going away? I don't know. And your coach is coming with you, you're going to need to pay for them. If you are the one in the tournament and your coach is coming along for you and he's employed by you, obviously you need to pay for that time. It's not free. Ms. Abramson continues, would it have been at all profitable? Oh, sorry. He says, no, it would have been out of the question. Now, let's go back in time if we can. First of all, there was a time prior to the first trial. Even there was a time when you had some calendar and appointment books that indicated the lessons that you taught to Erik and Lyle Menendez, correct? Correct. By the time of the first trial, those books were gone? Yes. Before those books were gone, though, did you prepare some documents indicating the dates in 1989 upon which you had given Erik Menendez tennis lessons? Yes. Ms. Abramson says, if I may approach the witness, Your Honor. The court says yes. Ms. Abramson says, I want to ask you, Dr. Heffernan, to look over these documents and then I will ask you some questions. Okay. First of all, is that your printing and handwriting on those pages? It is. And do those pages purport to represent dates upon which you gave tennis lessons to Erik Menendez? Yes. And did you prepare those from the appointment books and records that you had at the time? Yes. So these were not based on guesswork. I don't believe they were. And did you prepare those in response to a request from Mr. or Mrs. Menendez that you gave them some documentation to justify their paying for these lessons? Yes. So they were basically, you prepared them as a record, a business record, and gave it to them. Yes. And at that time that you prepared them, were you trying to be accurate? I was trying to be. I show these people, I'm sorry, to show these people that you weren't just taking their money, you were actually providing the service. Yes. Now, in this time period, those records, I believe, let me just double check. There is one sheet for dates in January. Yes, and that's 1989. I believe so. You didn't know them in 88, correct? In January of 88? No, no. And then there is dates for February of 1989. Yes, and there is another page of dates in January of 89. Yes. And then there is a page of dates in April of 89. Yes, and a page of dates in March. In fact, this one is dated March 31st, 1989. Yes, and another page that shows additional dates in February of 89. Yes, and an additional page of dates in February. Oh, she just said that question. Yes. Now, these aren't the only dates in 89 which upon you coached Erik. No. So this is just whatever documents you are able to put together in this package. Yes. All right. Did you provide us with these documents, if you know? I do not know that. Now, who would pay you before August 20th, 1989, if you had coached Erik, say 6 hours or 10 hours in a given day, who would pay you? Mrs. Menendez. And how would she do that? In cash or by check? By check. And was it the usual practice that she would pay you regularly whether you asked for it or not? No. Would you have to ask? Most of the time I had to ask. Sometimes would you have to ask more than once? Occasionally. And then she would write a check for you? Yes. And then subsequently, she asked if she could have something in writing to cover the check. Yes. And that's when you would prepare one of those sheets. Yes. And what is the letterhead on most of these sheets? California Graduate Institute Counseling Center. And what was the California Institute Counseling Center? Ms. Nahara says, I'm going to object as irrelevant, overruled. He says, it was a counseling center where I practiced psychotherapy. Ms. Amerson says, and you did your billings on that stationery? Apparently. Didn't even realize he did it. Didn't have any tennis coach stationery. No, I didn't have any tennis coach stationery. Okay, and so your specialty in psychotherapy, Dr. Heffernan, in sports psychology? Ms. Nahara says, I would object as irrelevant, overruled. He says, yes, it is. Now, as those records indicate, during the month that those records show, would it be fair to say that you taught Erik, on average, between 6 and 12 hours a week? That would be fair to say. And those records reflect January, February, March, and April of 1989. I believe we just saw that, correct? Yes. And in January, February, March, and April of 89, was Erik Menendez attending high school at the Beverly Hills High School? Yes, he was. And to the best of your knowledge, he was a full-time high school student, correct? Correct. And you also knew, did you not, that he was a member of the Beverly Hills High School tennis team? He was. And did that team play tennis matches? They did indeed. And as with every high school tennis team, did that tennis team also have after-school practice? They did. I am going to object, no foundation, lack of personal knowledge, overruled. The witness says they did have after-school practices, so he did know. He knew. Ms. Abramson said, and to the best of your knowledge, did Erik Menendez practice with his team? Yes, he did. In fact, you had to practice with the team to stay on the team, didn't you? Yes. And in addition to practicing with the team, did he also make more time in his schedule, as we have seen, to coach, to practice with you, and to be coached by you? He did. And how would you go about making arrangements, given Erik's attending school and his having strike that, in addition to his attending school full-time, playing matches for the tennis team, practicing for the tennis team, he was also involved in tennis association matches and tournaments? Yes, he was. Would you explain to the jury, Dr. Heffernan, that what the tennis coach or what the tennis association is and what these matches and tournaments are outside of the school context? Ms. Nahara says, Your Honor, I'm going to object as hearsay if he has no personal knowledge of that, as in being present as opposed to what he had heard from Erik as to what he was doing. The court says, do you have independent knowledge of those tournaments as to what they are generally? The witness says, yes, I do. Overruled. Ms. Abramson continues with her questioning. She says, as a tennis coach, you would have to know this, would you not? Ms. Nahara says, I would object. It's irrelevant if he wasn't aware of what Erik Menendez was specifically involved in. The court says, overruled. You can answer the question. Ms. Abramson says, can you describe for the record, for people who don't have tennis children or don't know for the record, what it is? He says, they don't know? Describe what it is. In Southern California, there are tournaments, a number of tournaments a year, probably weekly or bi-monthly or bi-weekly, where the Southern California Tennis Association puts on tournaments for juniors, adults, and seniors all year long, and there's statewide rankings for age groups and or adult level at different levels. And Erik was involved in tournaments in Southern California to get basically a Southern California Tennis Association ranking. And did he get a Southern California Tennis Association of Southern California ranking before his parents died? Yes, he did. And do you know what he was ranked? He was ranked, I believe 9 in Southern California in the boys, 18s. Now, what is is there a national tennis organization that then gets involved with the ranked players from all the different states? Yes. Ms. Nahara says, I'm going to object as irrelevant. Witness says, sorry. Court says, overruled. The answer will stand. There was no answer. Oh, he did say yes. Sorry. He said yes. All right. So Ms. Abramson says, and you were aware, were you not, Dr. Heffernan, that over the course of the summer of 1989, Erik Menendez, as a ranked California player, was playing in the national tournaments? Ms. Nahara says, I'm going to object that there is no personal knowledge, lack of foundation. The court says, perhaps you can establish his knowledge, basic knowledge. Ms. Like, so frustrating. Ms. Amerson says, well, first of all, did you work with Erik in the spring of '89 to help him prepare for a national tournament that he told you he was going to be involved in? I would object as hearsay, overruled. Witness says yes. And in fact, you knew from his mother as well that they were taking Erik to the nationals that summer. Yes. And in fact, you knew from discussing with your student that Erik had been to the nationals before. Ms. Nahara says, I would object, calls for hearsay, sustained. Ms. Abramson continues, is it standard for a ranked player in a state? California is considered a tough state for tennis ranking, is it not? I would object, irrelevant, overruled. Witness says, yes, it is tough. Ms. Abramson says, there is many, many good competitors in this state. Yes. And barring injury or the abandonment of pursuing tennis, would a ranked California player seek to participate in the national tournaments? Ms. Nahara says, objection, calls for speculation, overruled. Witness says, yes, he would. Ms. Abramson says, and as Erik's coach, you certainly encouraged him to participate in that tournament, correct? Correct. So getting a good national ranking is an important step in moving into professional tennis, isn't it? Objection, irrelevant, overruled. It's a good step. Yes, it is. Ms. Amerson says, it is a good step, and professional tennis is a career in which one actually can earn a living if one is good enough, correct? Objection, irrelevant, overruled. Witness says, if one is good enough. Ms. Amerson says, if one is good enough, and for those who are very, very good indeed, they earn a great deal of money, do they not? Yes, they do. Steffi Graf and those sorts of players, the ones and twos and on. Yes. In fact, is a living available for people who are not one or two or three or four, but for a number of levels on the professional circuit, can people earn a living playing tennis? Yes, I would say they could. I would say within the top 100 in the world, they could make a living at professional tennis, maybe more. Yeah, but you can't say it loud enough so I can hear you is the problem. He says maybe a 150 in the top world men's tour. So up to the top 150 can make a living playing professional men's tennis? Yes. Now, when we are talking about the national tournaments that Erik was participating in, that's amateur tennis. Yes, it is. And that's junior tennis tournaments, right? The ones he was competing in, yes. So there are also non-amateur junior tournaments, correct? National and local. And people who are, say, of college age compete in those, and seniors. And there are seniors. There are those for all groups, actually. Yes. But people don't get paid for competing in those, only in the professional ones where there is prize money, correct? Not correct necessarily. In junior tennis, there is no prize money. Senior tennis, there can be prize money. But Erik was in junior, so he was not competing. Prior to that time that you went to Israel, he was not even attempting to compete for money at that stage. Right. Now, you worked with both Erik and Lyle Menendez for several months before their parents' lives had been taken, correct? Correct. And for several months after. Yes. And did you form an opinion as to their potential to make that up to the top 100 to 150? Objection calls for speculation. Overruled. Ms. Abramson says, did you have the opinion, and I'm not trying to, okay, did you have the opinion based on your work with them that both Erik and Lyle Menendez had at least the physical ability, the talent to make the top 150, 100, 150 in the world? I would have liked to have thought so. Well, you decided to give up all of your other students just to coach them, didn't you? Yes, I did. And you did that in the hopes that they would be those kind of champions, did you not? I hoped they would. And you thought that they had at least the potential to do that if they worked hard enough and were coached properly. Yes. And if they had the mental fortitude and the strength to do it. Yes. Because there is a very important mental component of being a professional athlete, is there not? Profound. Profound mental component, and people who do not have that mental ability, no matter what the physical talents, aren't going to make it. Correct. Now, during the school year, before Mr. and Mrs. Menendez's lives were taken, during the school year, how would you or how would Erik strike that? How would you arrange to be coaching Erik given his busy schedule? Ms. Nahara says, Your Honor, I'm going to object to the use of the first name of the defendant by counsel. Sustained, and it's also vague as to what you mean. Okay. Ms. Abramson also feels the same way. She's like, all right. Did you make arrangements directly with my client to coach him on certain days when he was in school, or were those arrangements made between yourself and his parents or some other way? How would it happen that you would be coaching him? I mean, strike that, and I'll ask something simpler. Was there a set schedule where you would be coaching him every week on the same day at the same time? No, there was not. So how would the schedule get made then? We worked around his timing, and he and his mother would sit down, and sometimes I worked with Erik, and sometimes I worked with Mrs. Menendez, and we would figure that out. So you would try to sit down a week in advance and figure out what was coming up a week in advance, sometimes a day in advance. So you would be giving him a lesson, and at the end of the day, at the end of that, you would decide when the next one would be. Yes. So we would decide the next appointment at that appointment. And did you seem eager to have the coat? Blah, blah, blah. And did he? Oh my God, I cannot talk. I need a break. I'm talking too long. I'll take a break after this section. And he was trying to get as much time with you as he could. Well, he was a senior in high school. I wouldn't say he was totally eager, but he wanted to develop his game and he was busy. Was your lesson on average a 2-hour lesson? Yes, it was. And was it hard work for him? Yes, it was. And did he work hard? Some of the time he did, and some of the time he didn't. Some of the time, there was other preoccupations. This is not uncommon for juniors to have other issues in their life. And did it seem to you from time to time that he seemed to have serious matters on his mind even before his parents' homicides? I'm going to object. Calls for speculation from the witness. Sustained. Did he have what appeared to you to be concentration problems? I would object. No foundation. Calls for speculation. The court says, I will permit this one question and answer. Ms. Davidson says, thank you, Your Honor. You can answer that. Concentration problems? I would say that he had concentration problems occasionally. So just to fast forward a minute, after his parents died, did you see concentration problems? I would object, Your Honor, as irrelevant and has no foundation. Overruled. He had some serious concentration problems. And afterwards? Yes. Did he seem to have a lot of days when he was emotional after his parents died? Ms. Nahara says, Your Honor, I would object as irrelevant and no foundation. The court says overruled. Witness said, yes, he did. Ms. Amerson says, did he seem to have difficulty in working based on emotional problems? Ms. Nahara says, I would object, Your Honor. This witness would have no foundation for a conclusion or an opinion like that. Ms. Amerson says, he is a psychotherapist, Your Honor. The court says, okay, I will permit this one question and answer here. Ms. Amerson says, thank you. The witness says, yes, he had difficulty emotionally. Ms. Amerson says, was there a day, in fact, when Erik was living at, this is, by the way, called the Marina City Club, isn't it? It is. This complex in Marina del City, or Del Rey. Yes. And were you living in California when Marina del Rey was built? I came in 1980, so I believe it was already built. Okay, so you don't know if the Marina City Club was built right away or not? No, I do not. But it certainly wasn't built in 89, was it? No, it was not. Was there a day after Erik and Lyle Menendez had moved to the Marina City Club when you came upon Erik crying? Ms. Nahara says, I am going to object. It's irrelevant. Overruled. You can answer the question. And the witness says, yes, there was. Ms. Abramson says, and at the time that he was crying, he was holding a letter of some kind? Object is irrelevant. Sustained. You coached many juniors, did you not? Yes, over the years. And over the years, you were familiar with this usual emotional behaviors of 19-year-olds. If I didn't coach a lot of 19-year-olds, I played against them. Okay. And would you say it was common for a 19-year-old male to be crying? Objection irrelevant and lack of foundation sustained. Ms. Abramson says, let's go back, if we can now, to that period before Mr. and Mrs. Menendez's homicides. Were you charging for the tennis training of Erik and Lyle Menendez by the hour? Yes, I was. And Dr. Heffernan, given the commitment that you were giving or that you were going to make for that contract where you were going to be just a full-time coach only for Erik and Lyle Menendez, correct? Yes. So no other students. No other students. And this was going to be what? A 10-hour day? Yes. And for those 10-hour days, would it have been more expensive to go on your previous hourly rate, or more expensive to charge $5,000 to $6,000 a month? More expensive to go on my previous hourly rate if it was full. Absolutely. Okay. And the contract did call for full, and you were starting at some point training Erik and Lyle Menendez full time, your full time, and their full time. Yes. So it would have cost more had he charged his per hour charge than it did if he was doing the $5,000 to $6,000. So it's a discount. It's a bundle special by giving him like one flat rate. Where did I go? And even after Lyle decided not to pursue his tennis, I think you said that arduously you continued to train Erik Menendez full time. Yes, I did. And he had 6 10-hour days a week training with you? Yes, he did. And you had 6 10-hour days a week training with him? Longer. Longer? And if that had been on your old rate, it would have been something like $550 a day? Yes. Would have come out to about $9,000 a month just for him, wouldn't it? Yes, it would. Now, with respect to the teaching that you did for him before his parents died, did Mr. and Mrs. Menendez ever object to your teaching him a lot of hours in a particular week? Yes, they did. Based on the money? Based on his commitment. All right, I'm confused. The point I'm trying to make is, did they complain that you were costing them too much money? They never talked about too much money, no. Money was never an issue. Not really, no. Now, when you say they complained about too many hours based on his commitment, what does that mean? They wanted him to be investing if they were going to be investing. So, if they didn't think that he was working hard enough, they didn't want you to work with him? They held that over his head. They wanted him to be involved in his training or, do something else. So they hold over his head that they would cut back on your time if you didn't work hard enough. Objection misstates the witness misstates what the witness stated. The court says it would be better to let the witness explain his own answer. Ms. Abramson says, "Why don't you explain so I'm clear on what it means?" Well, if he, like other jurors, had off days and wasn't really trying hard, and Jose happened to see that, he would, a couple of times said, "Listen, we've got to talk about this. If you're not willing to invest and really grow up in the sport, we have to look at modifying the schedule." And he was 18 years old when his father was making those comments to him. Yes. Basically, was Erik trying to, I noticed, for example, if I may approach your honor, on these sheets, there are some periods when you appear to be spending a great number of hours. Let me see if I can find an example. Here's the page that covers January 11th to January 17th. That's a period of 7 days. That's 12 hours. Yes. During that period, yeah, and to the best of your recollection, was January 11th to January 17th a time when Erik was attending high school? Yes, he was. Every day, as far as you knew. As far as I knew. And there was some way that you were training him for 12 hours that day. Yeah, he wanted to play number one for his tennis team, and he was playing Southern California Association tournaments right then, and he was going to be playing nationals, and he wanted to get better. So he would work hard to improve himself, correct? Correct. And particularly when some matches or some tournaments were coming up, correct? Yes. And also when he was trying to accomplish some specific tennis goal, such as making the team at UCLA. Absolutely. That's so sad. He never got to go to school and do those things. You know, he didn't get to go to UCLA and get on the tennis team and be the things that he could have been. Ms. Nair says, "I'm going to object. Calls for speculation from the witness as to what the defendant wanted. The court says sustained. The answer is stricken." Ms. Abramson continues, "Did you have discussions with him about his wanting to work hard to make sure that he made the team at UCLA?" "I had discussions about what he wanted to do with his tennis, yes." "Did any of it have to do with the UCLA tennis team?" "Yeah, occasionally." Did UCLA have a good tennis team?" "Very good." "Was it a hard team to get on?" "I would say so." "And were you aware during the summer of 1989 that Erik had been accepted at UCLA and was going to be going there?" "Yes, he was accepted." "Were you aware of when it was that the UCLA school year began in 1989? "Not precisely. I believe it's late September or middle September." "So late August, September?" "It could be late August, yeah." "And in the spring of '89, were those discussions between yourself and Erik Menendez concerning your assisting him in getting ready for the nationals, the national tournaments?" "Yes." "And was there additional practice and work going on then so that he could compete in this national tournament?" "At least as much." "As much, if not more." "Yeah, if not more." "And you do know where? Well, let me ask you one other thing. These national tournaments, the National Junior 18s, for example, is this a tournament that's actually played a week at a time in different cities in the country?" "Yes." "And where is the last round, the finals, if you will, played?" "I don't know if there's a last round. There is different surfaces at different times of the year. So they have an indoor tournament. They have a grass court tournament. They have a clay court tournament. They have a hard court tournament." "I'm talking about just over the course of the summer in 1989. Were you aware of one venue for the National? The Nationals is really a series of tournaments, correct?" "Yes." "And you get ranked based on how you do in each of those tournaments?" "Yeah, or how you do depending on which ones you play. Some people, depending on their game style, play different surfaces, for example." "So you could do the clay courts, but not the hard courts?" "Yes." "Do the grass courts, but not the clay courts, that sort of thing." and your ranking is based on really who you beat. So how well you ranked were the people you beat? Yes. Okay. Were you aware that Eric Menendez, over the course of the summer, played in 3 different cities of this national tournament in Louisville? I got to remember, may I have a moment, Your Honor? Attorney Abramson confers with the defendant. Ms. Abramson says, okay, that's right. Ms. Nahara says, Your Honor, I'm going to object to the form of the question as lack of foundation if counsel is going to testify. Ms. Amerson says, I'm not going to testify. I'm going to ask him if he remembers. Overruled. Do you remember whether or not one round of that tournament in July was played in Burlingame, up near San Francisco, California? Yes, it's an individual tournament. They're all different tournaments. Yes. So that was one tournament that you were aware of. Yes. Were you aware of the tournament in Louisville, Kentucky? Yes, I was. And were you aware of the tournament in Kalamazoo, Michigan? Yes, I was. Is there a tournament in Kalamazoo, Michigan, to the best of your knowledge, for the juniors every summer? Yes, it is. Is it always the first week in August? I would think it would be. Just as the US Open is always the last week of August, first week of September? Yes, there are important junior tournaments. And they're sort of set in the venue, and the place is the same every year, especially Kalamazoo. And that's the last one on that tournament, sir. I think there's an indoors in the fall, but this is a very big tournament, Kalamazoo. So the last one of the summer, yes. And were you aware over the course of that summer that Eric Menendez was attending these 3 tournaments? Yes. He was training with you before any of them? Yes, he was. Were you aware that he also went to a tennis camp in Florida in between the tournaments to train for them? Yes. And did you know the name of that camp? It was either Bolletero or Hotman. Is Harry Hotman's tennis academy at the Saddlebrook Country Club in the Tampa area? Yes, it is. So, to the best of your knowledge, Dr. Heffernan, was most of Eric Menendez's time over the course of that summer spent training for and competing in these tennis tournaments? Yes. He wasn't at the beach? I didn't see him there. Court says, how much longer? Ms. Amerson says, a goodly period of time. You should probably said a good period of time if the court wanted to take a recess. Court says, okay, we'll take a recess until 5 minutes after the hour. The witness says, can I leave this here? Is that possible? The court says, sure. A recess was taken. The court is back and says, okay, you can retake the witness stand. Okay, we'll have the jury come out. Court says, okay, the jury is back. You may continue your cross-examination. Ms. Abramson says, thank you, Your Honor. I want to go back to the beginning of your contacts with the Menendez family, Dr. Heffernan. How did it come about that you made contact or contact was made with you by any member of the Menendez family? When I first met them? Yes. I frequented a tennis shop in Los Angeles. I referred my students there. It was a tennis shop that provided pretty good service, a lot of good quality products. And so I was there one day talking about tennis and racket stringing and various things. And the manager of the shop said, Ms. Abramson says, this isn't being offered for the truth, Your Honor, only to explain the witness's actions. The court says yes. I don't know if there was an objection there or what. The court says or the witness continues, there was a young hot shot from Princeton that wanted to play some tennis, and would I like to play him? And I said sure, and so I phoned Lyle. He gave me his number, and I phoned him, and we arranged a tennis match at his house. Ms. Emerson says, and did you play this match? Now, you phoned him to just meet a good player from Princeton, or did you have in mind that maybe the good player from Princeton wanted a coach? No, I was competing myself, so I wanted to train. So you wanted to play the best players that you could hear about around LA? Yes, to play with. That's one of the ways to get better is by playing people who are very good. Yes. And in your opinion, would someone who was in the Princeton University tennis team be a good player? Absolutely. That's also a very good tennis team. Yes. And were you say the manager described Lyle as a hotshot. Did he tell you? No, no, he didn't describe him as that. Did he describe him as number one on the Princeton tennis team? I think he did. And number one on the tennis team would be a formidable. The court says, now we're getting into this for the truth of the matter and it's irrelevant, so objection sustained. Ms. Abramson says, did you then arrange to play Lyle Menendez at his home? Yes. And at that time, was he living on Elm Drive in Beverly Hills? Yes, he was. And did you play him? Strike that. Who else was present when you played him? Nobody at first. And then I think Erik came, I believe, with a friend. And then, if I'm not mistaken, maybe Jose came at the end. It was, I think, on a Saturday. So Jose maybe watched the last 10 minutes, or Erik watched maybe a little more. How'd you do? Objection irrelevant, sustained, although we're very curious to know. Well, then why didn't you let him answer that? All right, so Ms. Amerson says, I think it's relevant. The court says, go ahead. It's not. Go ahead. Ms. Abramson says, to what happened after? Ms. Abramson continues, after this match with Lyle Menendez, were there any discussions about your coaching him? Hold on. Sorry, the dog was bugging me for her blanket. All right. So Ms. Abramson again says, after this match with Lyle Menendez, were there any discussions about your coaching him? At the time, not coaching him as much as maybe hitting with him occasionally, more maybe possibly working with Erik. Who did you have the discussions with about possibly working with Erik? I think Lyle and Mr. Menendez. So then that was on the occasion that was on the occasion that you played. When you play Lyle, sorry. No, I think it was later than that. Okay. Did you play Lyle again before these discussions that involved Mr. Menendez, when Mr. Menendez occurred? I don't know. The writing in this is terrible. I have to adjust sometimes, so apologies. He says, yes, I believe I did. And was that also at the family court? Yes. And do you recall if Mr. Menendez was present when you played that game with Lyle? I can't remember. But at some point after that, there was just a discussion about your coaching Erik? Yes. And were the arrangements for that made with Mr. Menendez? Yes. Were you at that time a good tennis player, Mr. Heffernan? Objection irrelevant, overruled. You can answer that question. The witness says, good is relative. Ms. Abramson says, good for your age group? Yes, more my age group, I'd say, for sure. They they were doing me a favor playing with an old guy, you know. Oh, okay. Youth is very important in the game of tennis, is it not? It is an asset. Now, as it turned out in January of 1989, did Lyle Menendez leave California and go back to Princeton? Yes, he did. And he wasn't available then for you to be coaching him once he was back to school on a regular basis? On a regular basis, yes. Is that true? That's correct. When he'd come back home for school breaks and such, did you give him lessons then? Yes, I did. But mainly you were coaching Erik. Yes. Now you've testified that you believe the last lesson that you gave to Erik before his parents' homicides, first of all, you're certain, are you not, that it was in the week before their lives were taken? Yes. So you've testified based on Ms. Nahara's questioning that it was the 18th. Do you recall testifying to that? I believe so. Are you absolutely certain it was Friday the 18th, or could it have been Thursday the 17th? I believed it was Friday the 18th, but I'm not 100% certain. I can't remember those dates. And even before this first trial, you did not any longer have any of your appointment books with which you used to refresh your recollection. Is that true? That's true. I usually, at the end of the year, I dispose of them. In therapy, we can't do that, but in tennis coaching, I can. Right. And to the best of your recollection, well, strike that. Were there occasions during that summer where you would teach Erik or coach Erik on Saturdays and Sundays? Yes. Now, do you know for certain that you did not give him a lesson on Saturday the 19th because the family was going on a fishing trip? Yes, I would say certainly that I knew that. And therefore, you were not at the home at any time on Saturday the 19th. No, I wasn't. And in fact, you were not at the home at any time on Sunday the 20th. No, I was not. You got there in the early morning hours of Monday the 21st after you were called by Erik and Lyle, correct? Correct. Now, if Erik and or Lyle had been working with other coaches than yourself in Los Angeles that summer, do you believe that's something that you would have known? Yes, I think I would have known that. And you did in fact know that they had no other coach but you. Objection calls for speculation. Sustained. Did you have any reason to believe that they were working with any other coach but yourself? No. Now, from your working with both Erik and Lyle, well, strike that. Can you determine if you are a personal tennis coach, such as yourself, when you're working with a student who has been professionally coached before? Can you tell in the way that they play whether or not someone's had a professional coach before you arrived on the scene? Objection, irrelevant, overruled. Yes, I can tell that. Ms. Amerson says, and could you tell when you were training Erik and Lyle Menendez that they had been professionally coached before? Yes. And did it appear to you that they had been professionally, based on the way that they played and the way that they dealt with you, that they had been professionally coached for a long time? Objection calls for speculation. Overruled. Yes, I believe they'd been coached all throughout their junior career. Throughout their junior career, starting when they were children. Objection calls for speculation. Sustained. Did you notice did you notice at any time when you were at the Menendez home that there was basically a wall of trophies for them? Yes. And they didn't win all those trophies during the time that you knew them, did they? No. What did you do in the early morning hours of August 21st, 1989, after you received a telephone call from Erik and Lyle Menendez? I drove to the house and talked to them and the police, and we went to the police station. When you got to the house that morning, did you see Erik Menendez? Yes, I did. Objection, irrelevant, overruled. Can you describe his demeanor and what he was doing when you saw him? Objection, irrelevant, overruled. I think he was lying on the street and he was crying unconsolably. Oh, poor Erik. Ms. Abramson says lying on the street with what was his position of his body? He was sort of in a fetal position. Oh my God. And did you go to the police station with him or did you follow in another car? How did that happen? I believe I followed in another car. Do you know how they got to the police station? They being our clients? I believe the police took them. So they took them in a police car. Yes. And when you got to the station, did you observe each of them in a series what? In a series, did you observe them accompany a Sergeant Edmonds to a room to be interviewed one at a time, is I think what she means. Yes. And after, it is your recollection that Erik was interviewed first and then Lyle was interviewed? I can't remember that. Can't remember which went first? Yes. Do you recollect, however, that after both of them were interviewed, Sergeant Edmonds talked to you? Yes, he did. And that was very brief, was it not? It didn't feel brief. Okay, after you talked to Sergeant Edmonds, did you leave the police station? Shortly thereafter. Within minutes? I guess, I'm not sure of the time. Do you remember doing anything else at the police station after Erik Menendez, Lyle Menendez, and yourself talked to Sergeant Edmonds? I don't remember doing anything else, but it's longer term than we'd sit around and wait and find out instructions, and I don't know how long it took. But at some point, you left with him. Yes. Would you say within an hour or an hour of your interview? I would say so. And when you left with them, where did you go? I went home. And they went to your home as well? Yes. Do you, at this time, have an independent recollection of when it was the precise time when you were interviewed by Sergeant Edmonds? No, I don't. Did you know that Sergeant Edmonds was tape recording the interview? I believe he told me that. Do you think it might refresh your recollection if I show you a transcript of the interview which has the time on it? Certainly. Ms. Abramson says, "If I may approach, Your Honor, I'm happy to mark. Let me see if this is. I have an untagged version, which would make it better. So they're both tagged. Forget it. I'm marking this 125 at this point, Your Honor. I don't know if you've ever seen this transcript before, Dr. Heffernan. I don't think I have. Let me call your attention, however, to what appears to be the opening words. Do you recall when Sergeant Edmonds started that he announced on the tape what day it was and what hour it was? Yes, I think so. Would you look at the opening sentence and tell me if that refreshes your recollection as to what time it was that you sat down with Detective Edmonds? Approximately 2:30 in the morning. And if I show you that this entire transcript consists of 4 pages and show you the closing time, does that refresh your recollection as to what time it ended? Yes, 2:33. So the whole interview went from 2:29, is that what that says? Correct? To 2:33. Yes. Long, 4 minutes. Very long. So somewhere between 2:33 when this ended and 3:33. What? No, 2:30 and 2:33. You left the police station with Erik and Lyle Menendez. Yes. Now, turning again to a few days before that, the last lesson you gave before they called you to tell you the last lesson you gave before the interview that you had with Sergeant Edmonds. Are you uncertain as to whether Erik or Lyle Menendez you gave that lesson to? I believe it was Erik. And you realize you've previously testified that it was Erik. I guess so. Did anyone send you the transcripts of your prior testimony in this trial? Not this time. I think I looked at some notes from the last trial. Before you testified at the last trial, did you have copies of the various interviews you had participated in? I believe so. You've talked to you've talked to the police department on several occasions. Yes. You talked to the previous prosecutors, Ms. Bazanich and Mr. Kuriyama. Yes. You talked to the defense in the past. Yes. But since the last trial, you have not seen the transcripts of your testimony at that trial? That's correct. Okay. You realize if you don't remember something now that you believe you knew then, we can show you pages from the transcript. You'll probably have to, he says. Okay, we'll see. So far, you're doing fine. Did you, later in the morning on August 21st, after you had taken Erik and Lyle Menendez to your home and your wife was home, was she not? Yes, she was. And as far as you knew, your wife had a friendly relationship with Erik Menendez. Yes. Objection calls for speculation, overruled. And at some point later that morning, did you leave your home and return to the house at Elm Drive? Yes. And did you go there with Erik and Lyle Menendez? No. You went there by yourself? Yes. What time did you go there? I believe like between 7 and 9 in the morning. Why did you go there? To help them, really? Were they going there? They weren't at my home when I woke up. Okay. And I believed that they were there. So you went there and you saw them there? Yes. What time did you wake up? I'm not sure. I don't remember. What time do you usually wake up? 6:15. Did you have any contact with any of the police officers at the home when you got back? I'm sure I had some contact. So you don't have any specific recollection of it? No. Ms. Nahara says, make a motion to strike the previous answer. The court says, overruled. The answer will stand. Ms. Abramson says, now, after that, when did you see next? Sorry, I can't. Blah, blah, blah. Brain, stop it. It's like after so long, I get cross-eyed and tongue-tied, and I can't process. Now, after that, when did you next see, when and where, after you saw them at the house, did you next see Lyle or Erik Menendez? And that wasn't a very clear question either. I believe it was at the Bel Air Hotel. And were there other family members at the Bel Air Hotel when you saw them? Yes. And how many days, if you can remember, after Monday, August 21st, did you see them at the Bel Air Hotel? 3 or 4 days. And had you previously met any family members of their family? Yes, I had. I'm going to object as irrelevant. Overruled. The answer will stand. Do you recall now who you saw at the Bel Air Hotel when you saw Erik and Lyle Menendez? I'd object as irrelevant. Overruled. I believe Carlos was there. Carlos Baralt? Yes. Terry's husband. Yes, Terry's husband. You know their aunt, Terry Baralt. Yes, I do. Who else? Maybe their Uncle Brian? Brian Anderson. Brian Anderson. Those are the two men I remember specifically. Dr. Oziel was there. Did you know Dr. Oziel before that? No, I didn't. Was there some reason why you recalled him being there? Objection, irrelevant. Could you describe how Dr. Oziel was behaving with respect to Erik and Lyle Menendez on that occasion? Objection, irrelevant. Overruled. Yes. He was talking to them sort of in a clandestine manner over in a corner somewhere. So secretively. I'd object to the term clandestine, Your Honor. It's speculation on the witness's part. The court says, well, it's descriptive in a certain way. Objection overruled. This is a good day for the defense, actually, with the overruled objections by uh, Judge Weisberg so far. Ms. Abramson says, did he appear to you to be overbearing and domineering with respect to them? I'd object, Your Honor. It's irrelevant. It's also speculation. Sustained. I'd like to be heard on that, Your Honor. When the court has an opportunity, the court says, all right, move on to something else, please. Yes. Did you visit with the family at the Bel Air Hotel? Objection, irrelevant, overruled. I believe I did somewhat. And did you later attend any kind of memorial service? I did, but I came late. I missed a lot of it. I admit that. I must admit. So do you remember what day the memorial service was on? No, I don't. Do you recall being told by Erik Menendez that he was leaving California after the memorial service and going back to New Jersey or New York? Objection, calls for hearsay. Sustained. Well, did you previously testify that Erik told you he was going to be in New York on direct examination? Objection, vague as to time. Overruled. The witness says, I can't imagine him telling me that. I believe he did leave, in fact, but Miss Amerson says, were you aware that there was a funeral planned in New Jersey after the memorial service in California? Yes. To the best of your knowledge, were you told that the whole family was going back east? Objection, hearsay, sustained. As to what he told you, that's hearsay, sustained. So Ms. Abramson says, how long after? I'm just trying to do a quick dating in my head, Your Honor. Give me a moment. The Friday following August 21st would have been August 25th, correct? Correct. How long after did the U.S. Open begin? Shortly. When did you go back east? I believe I went back probably the Sunday 27th. Yes, I think so. I was at a convention there for coaches, national coaches, and it was all week long. And the convention coincided with the U.S. Open. Yes. And lots of the coaches would go, yourself included, would go and watch certain matches at the US Open? Yes. Had you communicated to Erik Menendez sometime after August 21st that you were going back east to the coaches' convention? Yes. And were you back east when you were contacted? Well, strike that. When you were back east, you've testified at some point that you saw Erik Menendez at your hotel. Yes. And your hotel was in Midtown Manhattan, was it not? Yes, it was. And the US Open was played in one or two venues in the Bureau of Queens, correct? One venue. At Forest Hills? No. In Flushing, at the stadium there? Flushing. Flushing is in the Bureau of Queens, I believe it is. And was the play at the US Open in a stadium on the site of the World's Fair grounds in Flushing Meadows? Yes, the World's Fair grounds were close. Close. So you could tell because there was a huge globe-like thing there. Yes. Left over from the 1962 World's Fair. Yes. The court says, let's get on from our tour guide to something more relevant. Miss Abramson says, just to pin down where you were, Your Honor. Now, when you saw Erik Menendez in New York, this would have been in the last few days of August or the first few days in September, is the best that you can recall. Yes. Was the only time that you saw him when he was at your hotel room? I believe that's true, yes. And did he call you and make the arrangements to meet, or were you told by your wife that he called? I can't remember that. And when he came and saw you at your hotel, in fact, didn't he wind up spending the night in the hotel room with yourself and your wife? Yes, he did. And did you understand that he wasn't able to find a hotel room for himself in New York? Objection calls for hearsay. Sustained. Did he ask if he could come spend the night in your hotel room? I don't know if he asked. My wife probably volunteered, knowing her. Okay. And do you recall that the next day after he did leave the next day, he only spent one night, correct? Yes. And do you recall the next day you and your wife discovered that he had left many of his personal possessions behind? I'm going to object to anything referring to his wife. Sustained. Did you observe that Erik had left many of his personal possessions behind? Clothes, shoes, things like that? I believe he left some things, yes. And can you describe what his demeanor was like when you saw him at your hotel in New York? Objection, irrelevant, overruled. Demeanor? Nothing particularly comes to mind. I'm just not. Do you recall previously testifying that he appeared to be in mourning? Objection calls for conclusion from the witness. Speculation sustained. Well, did he appear to be sad, grief-stricken, somber? Objection, Your Honor. I believe it's been asked and answered. Overruled. I believe he was certainly different than the Erik I had known before the homicides. Different how? Well, I would say that he was sadder, more quiet. Was the US Open televised that year? Yes, it was. Isn't it always televised? Yes, it is. Now, after the coaches' conference that you attended for the week, did you return to Los Angeles? Yes, I did. And do you know how long after you returned that you saw or heard from Mark, from Erik Menendez? No, I can't remember that time. And there was some measurable period of time, was there not, between the time that you got back and the next time that you gave him a tennis lesson? I think there was, yes. And when did you start teaching him again? Was it within just a very short period of time that the two of you started talking about his working full time on tennis? Yes. Now, you've testified here that you think maybe the resumption of his resuming his tennis lessons, and the beginning of those discussions with you occurred in September. I just can't remember the dates. I believe sometime in September I taught him. Do you recall testifying at the previous trial that these discussions actually began sometime in either October or November? I can't remember that. In any event, Whenever it was they began, did you start teaching him full time even before the date that the contract was signed? I believe I did. And even before the date that the contract was signed, were you being paid in accordance with the compensation terms of that contract? I guess, yes. But you gave up your students even before there was a signed contract? Well, then I definitely was getting paid. Well, I'm asking you. I didn't talk to any of your students to find out, but well, yeah, if I was getting paid for full-time work, I wouldn't have been working with anybody else on the side. So you've previously testified that there was a period of at least 2 months before the contract was signed that you believe you gave up your students and was being paid in accordance with the terms of the contract. Well, if I said that, that's true. Okay. Now, were there two people in addition to Erik and Lyle Menendez who discussed the terms of the contract with you and participated in the negotiation and drafting of the contract? I know Marta did. I'm not sure if there was anybody else. How about Stephen Goldberg, the lawyer? Oh, yes, absolutely. And in fact, Stephen Goldberg, the lawyer, wrote the contract, didn't he? Yes. So you certainly didn't write that contract. No, I didn't. He asked me if he wanted to. So remember, Steve Goldberg was the attorney that the family hired, I think, for like the uh, executing the will. I couldn't think of the word executing. To execute the will, and I think he was, among other things, the financial lawyer for the family, and keeping track of that stuff. So, um, he says he declined. Wait, what? Where was I? So Steve Goldberg, no. Wait, yes. And in fact, Steve Goldberg was the lawyer who wrote the contract, didn't he? Yes. And you certainly didn't write that contract. No, I didn't. He asked me if I wanted to. Oh dear. And you declined? I declined. And Marta Cano, as far as you understood, was Erik and Lyle Menendez's aunt. Yes. And she was the sister, as you understood it, of Jose Menendez. Yes. And she was involved in negotiating terms of that contract? Yes. Now, subsequent to the decision being made that you would work with Erik full time, did you start receiving checks bi-weekly for your services? I believe I did. And do you recall where the checks were coming from? I believe Florida. And do you remember that checks were drawn on a bank in New Jersey? Yes, I think that's true. And were you told that Marta Cano in fact lived in Florida? Yes. I'm going to object to anything he was told as hearsay. Sustained, the answer stricken. Do you have any recollection of whose name was on the account of that New Jersey bank, the New Jersey bank checks? Objection. Going to object as to anything on the checks as hearsay. Overruled. I can't remember right now. Did you believe it was a trust account of some sort? I'm going to object to anything calling for speculation. Sustained. Did you previously testify that it was a trust account of some sort? I would object. Same objection. The court says, well, unless the answer or the particular testimony can be read to this witness, objection sustained. And Ms. Abramson says, I'll get to it. Now, even before do you recall, Dr. Heffernan, in that month, it was that Erik and Lyle Menendez took up residence in the Marina City Club? Perhaps October. And is that where you were working with them on the sports science coaching? Yes. Did the Marina City Club have the appropriate facilities for the kind of athletic work? For the most part. It had a gym? Yes. It had tennis courts? Yes. And to do the kind of training that you had discussed with Erik and Lyle Menendez, you would need those facilities. At least. And more, perhaps. And more. And those facilities did not exist at the home on Elm Drive, did they? No, they did not. And when they were living at the Marina City Club and you were training with them 10 hours a day, were they doing more than just playing tennis with you? Yes, they were. What else were they doing? Strike that. The more that they were doing, Was that designated or designed by you? Were you the person who designed the program? Ms. Nahara says, I'm going to object as to we. I think it's vague as to who's doing what. Ms. Abramson says, we. Did I say we? Where did she say we? She didn't say we. The court says, well, why don't you just say it all over again? Okay. I wasn't there, was I, Dr. Heffernan? First of all, was there a period of time when you were training the two of them together and equally? Yes, there was. And then, as far as you understood it, Lyle left and you were just training Erik. Yes, that was at the end, though. Lyle was involved for a long time. Did the training have to do with other kinds of work than just practicing various aspects of tennis? Absolutely. And what were those other areas of work? We did we did weightlifting, different physical work in the gym. We hired an Olympic class weightlifting coach, and they were being coached by the weightlifting coach. Yes, we went through a program. We designed a program for them. We did work in the water, sort of an aqua training system. We did work at the Santa Monica Track Club, and we worked with different perimetized running drills. So, like, you go in sections of a perimeter? I don't know. Pyramid? Pyramidized? So, like, I don't know sports science. I'm assuming like just running drills, like you would run from one to, like, we used to do that in, oh my God, this is aging me, but like back when I was in like grade school, we had running drills in basketball. So I'm assuming that's what that is, depending on the time of year. He says, we were trying to get them ready for the next year at a high class level physically. So we worked with different lengths and types of running, those types of things. I had a nutritional profile done on them by a holistic doctor, and we modified their diet and supplemental work so that they were getting proper nutrition, counseling, and supplementation. I did mental work with them daily, both educationally and process work, doing visualization, different things like that, arousal control, cognitive restructure. And this is all having to do with tennis? Yes, performance, I guess. And how to perform best at tennis, right? Yes. All right. And so this day would be filled with all of these activities plus the actual tennis instruction and eating and eating. And would you, in fact, go over in the mornings and wake them up and get them started? Yes, I would. He had to wake them up. And you'd stay with them all day, all day, 10 to 12 hours. Yes. And what time did this day begin? 8 a.m. And this was 6 days a week. Yes. Is it your recollection, by the way, going back to that period of time when you were negotiating the contract, that those negotiations were going on long after the school year had begun for UCLA? Yes. And you were aware that Erik did not attend UCLA that fall in spite of having been accepted? Yes. Is it hard work to become a professional tennis player? Objection, irrelevant, overruled. Yes, it is. Did Erik work hard? Some of the time. Other times he seemed to have problems concentrating. Objection, assumes a fact not in evidence, also irrelevant, sustained. Did he seem to have problems concentrating? Objection, irrelevant, sustained. Why was she able to talk about it before and not now? When you said some of the time what he was doing when he wasn't working hard, what was he doing when he wasn't working hard? Going to object as relevant, overruled. He was doing a number of different things, I guess. He was with his friends occasionally. He just had a number of different things he was doing. Ms. Abramson says he had a girlfriend also, starting in January. Didn't he? Yes. Did you meet her? Yes, I did. What was her name? Objection, irrelevant, sustained. When you and Erik were in Israel in February, could you describe his demeanor there? Objection, irrelevant, overruled. Anxious. Respondent. Did he appear lonely? Yes, very. Objection irrelevant. Overruled. And what was the evidence to you that he was lonely? Objection, Your Honor, calls for speculation from the witness. Sustained. Was he on the telephone a great deal of the time? Yes, he was. Could you overhear him talking to his girlfriend? Object to anything said, Your Honor, as hearsay. I'm not going to ask about anything that was said. The court says you can answer the question. Ms. Nahara says objection calls for speculation as to who he was talking to. The court says you can answer the question. Overruled. The witness says some of the time he was talking to his girlfriend. And this was the same girlfriend, Noel Perleski. Objection calls for speculation. Sustained. As far as you knew, he only had one girlfriend during January and February. Objection calls for speculation. Sustained. My goodness, this is annoying. All these sustains now. He was really going in favor of the defense, and now all of a sudden, sustain, sustain, sustain. I don't think her questions are that improper. So I don't know. Ms. Aronson says, did you only see one girlfriend with him? Yes. The court says, there's a hum. Is your equipment on over there? The witness says, it sounds like it is, like it's here. Ms. Aronson says, probably the air conditioning system, Your Honor. The court says, no, maybe it's coming from the lights. Ms. Abramson says, probably the refrigeration system. The court says, no, it's getting rather warm in here. The witness says, things are heating up. Ms. Abramson continues, now you've testified that at some point you became aware that Erik purchased a Jeep. Yes. Do you know the difference between a Jeep Wrangler and a Jeep Cherokee? Yes, I do. I want a Jeep Wrangler so bad. Like, that's my dream car. I want one so bad. Yes, I do. Now, you know which one was more expensive in 1989, the Wrangler or the Cherokee? I think the Cherokee was more expensive. And do you recall that Erik bought the cheaper model, the Wrangler? Yes. Were you with Erik when he purchased the Jeep? No, I wasn't. Did you see him talking to anyone else by way of advice or negotiation to purchase the Jeep? I can't recall that. Did you ever talk to Steve Goldberg about the purchase of the Jeep? Objection calls for hearsay. Did I? Yes. Overruled. You can answer the question. The witness says, I can't remember that. Did you ever see Steve Goldberg visiting Erik and Lyle or Lyle at the Marina City Club? Yes. Were there occasions, Dr. Heffernan, where you would be teaching Erik before his parents died at the home when one or both of his parents were observing the lessons? Objection, irrelevant, overruled. Yes, they were. And on how many occasions would you say you observed either or both parents being out there near the court while you were giving a lesson? Infrequently. So no more than 5. Well, I can't say that. I taught them a long time, so infrequently, I'll say. All right. On any of those occasions, did you hear Mrs. Menendez offer criticism or commentary or instruction to either Erik or Lyle Menendez during a lesson? Objection, irrelevant, overruled. This is relevant because they said that, the pool guy, Grant Walker, said that the brothers were just yelling and swearing at the parents, and the parents were just giving advice or whatever. So if he had never seen that, then that kind of throws his credibility out the window. And guess what? The witness says, I can't remember criticism really from her or instruction. No, I don't think so, he says. Did you ever hear Mr. Menendez make comments or give instruction or in any way get involved in the lessons? He was involved sometimes. So there was a difference between the two parents on that score, was there not? Yes. He would say things she would not. Yes. And on the occasions when Mr. Menendez did say anything, did you ever see either Erik or Lyle Menendez curse him, scream at him, use vulgar words in that direction? I'm going to object to anything as outside the scope of direct and also irrelevant, overruled. The witness says, no, he never screamed or swore at them. So Erik or Lyle never did, I guess. By he being Erik? No, he being Jose. Oh, okay. So he's saying Jose never screamed or swore at them. No, I'm talking about Erik and Lyle. Did they ever scream or swear at their father? I don't think so. You've previously testified that never happened. Yes. So you don't remember them ever talking to their father that day, do you? No, I don't. And you never saw Mrs. Menendez say anything at all during the lesson, correct? Yes, if anything, very little. Now, were there times, however, during lessons when Erik and Lyle would do anything in their play that they were unhappy about? Yes. And were they unhappy at themselves? Objection calls for speculation. Sustained. Did you see Did you see them miss a shot or do something wrong and get angry with themselves? Objection calls for speculation. Overruled. Yes. And curse at themselves? Yes. And is that common among competitive players? It's a gentleman's game. So you're being facetious, and believe me, that doesn't work on record. I'm sorry. Yes, that's true. That would be common. Were they hard on themselves when they missed or made mistakes? Objection vague as to what that means. No, it's not. Sustained. Did you see Erik being self-critical about his game? Objection irrelevant. Sustained. Did you hear him verbalize self-criticism about his game? Objection irrelevant. Overruled. Yes, I did. Did you hear Lyle Menendez verbalize self-criticism about his game? Objection irrelevant. Overruled. Yes, I did. Do you, in fact, well, strike that. Isn't it true, in fact, Dr. Heffernan, that you never heard Erik Menendez say anything negative towards or about his father? Objection irrelevant. Overruled. That's true. This looks so bad for the state that they have to object to just about every question being asked of this witness. It's their witness that they called, and most of it is he didn't help them. I don't know how he progressed their narrative at all. If anything, he's completely helpful for the defense so far. I mean, he hasn't said anything like incriminating for the brothers. Isn't it true, in fact, Dr. Heffernan, that you never saw Erik Menendez say anything negative? Objection irrelevant. Witness says true. During the summer, when Erik Menendez was involved in these tournaments, did you find yourself in New York with Lyle Menendez? Yes, I did. And was that in the month of July? Objection irrelevant and outside the scope of direct. Sustained. Ms. Abramson says, Your Honor, this is an area where I think I'd like to spare the witness having to come back. The court says, objection sustained. Ms. Abramson says, well, I'd like to be heard about that when we have some time, Your Honor. The court says, certainly. Ms. Abramson continues, when you were working out the schedule with Erik Menendez for his full-time training or after that training began, did he request that you set up a schedule where every hour is determined in advance, everything is known in advance that he'd have to do? Did I determine that? Did he ask you to do that? I can't remember that. Was the program that you designed a highly structured program by time? Yes, I would say so. With respect to these discussions that you had had with Erik and Lyle after their parents were dead, did they seem to possess more drive vis-a-vis wanting to improve their tennis careers? Objection, irrelevant. The court says it's ambiguous what you mean. No, it's not. Ms. Abramson says, let me ask you this. Before their parents were dead, did it appear to you that they had an interest themselves in pursuing tennis and getting better in it? Objection calls for who is they, says the court. They being Erik and Lyle. Objection calls for speculation. Sustained. My God. Abramson says, is this an important factor for you as a coach? What is? I was going to ask. The court says the objection was sustained to the previous question, so The question is off the record. You have to ask another one. Ms. Abramson says, well, I'm trying to. I am. Is the motivation of a student to improve themselves and to be disciplined about the game important to a coach? Objection, irrelevant, overruled. You can answer the question. The witness says, yes, it's very important. And have you seen situations where all the drive is coming from the parents and none of the drive is coming from the kids who are the subject of the teaching? Objection, irrelevant, sustained. Is this family, before the parents were dead, did it appear that the only reason that Erik and Lyle were playing tennis is because they were being pushed, or did they seem to be self motivated to do well? Objection, calls for speculation, sustained. Ms. Abramson says, in your relationship with Erik over the months that you worked with him, did it appear important to him to do well in tennis? Objection, calls for speculation, overruled. Yes, you can answer the question. Yes, he says. This is so annoying that everything's being objected to. It really throws off the lawyer who's asking the questions too, because they have to keep rephrasing their questions and trying to figure it out. And it could be on purpose to throw her off. I'm not sure, or could just be that there's a lot here that he could say that could hurt the state's case. Ms. Aronson says, was it a component of his self-esteem that he do well? Objection, no foundation, sustained. Next question, please. Was he, when Erik would win, would that I object to the use of the first name by counsel? Rephrase the question. You never referred to them as the defendants before today, did you? Objection, irrelevant. It certainly is. When my client would play a game or a match and win, was he satisfied with himself? Objection, calls for speculation and no foundation. As phrased, it is. Did he express satisfaction with his game? Some of the times he did, yes. Were there times, even when he won, that he didn't express satisfaction when he expressed dissatisfaction with his game? Objection, irrelevant, overruled. You can answer the question. Yeah, I would say that you can win without feeling good about it. I think he probably at some point, we talked about that he didn't play his best. I'd object to anything after probably a speculation motion to strike, overruled, the entire answer will stand. Next question, please. Thank you. Did Erik Menendez ever complain to you during the time that you were training him full time about having nightmares that kept him up all night? Objection, irrelevant, and calls for hearsay, sustained. Were you ever aware before the first trial that Lyle Menendez wore a hairpiece? No, I wasn't. Could you ever tell in playing with him that he wore a hairpiece? Objection, irrelevant, sustained. Your Honor, that's all I have now, but there are areas that I'd like to go into, so in anticipation of a discussion with the court, I would have no other questions at this time. The court says, okay, very good. Do you have any examination of the witness? Mr. Gessler says, I do, but in a similar situation, I also would like to ask the court, ask certain areas, Your Honor. The court says, all right. What we'll do then is take a recess and resume at 1:30. The court says, okay, we're in recess until 1:30. And then they're going to get into some oral arguments. Excuse me, Your Honor. Could I inquire if the court felt there was an adequate foundation for those billings? I'd like to mark them next in order. The court says, didn't we do that? Abramson says, no. Mr. Levin pointed out to me that although we discussed them, I didn't give them a number. The court says they'll be marked as 126. All right, now a recess was taken. In the trial, we have the defendants, their lawyers, and the people are here. When we broke off at the lunch hour, I believe there was some request for further examination by defendants. Is that it? Ms. Amerson says, yes, Your Honor. The court says, okay, what was it? There are 4 things, actually, 3 main ones. First, I wanted to be able to elicit from this witness that based on his observations of the defendants and their parents over the length of time that he was around the family, that this was not an obviously affectionate family. He did not have a sense of warmth in that household. He never heard any terms of endearment by the parents towards the children. And I offer that to counteract the testimony of Perry Berman, from whom the people elicited over objection that Mrs. Menendez was warm and sweet. He said only to him, to Perry Berman. He never said that she was warm and sweet to her own children. I would also ask him, and he is prepared to testify that he saw occasional hugs by Erik of his mother. The second topic is, wait a second, the court says, do we have the jurors here? The bailiff says, they are in the hallway. Court says, okay. All right. Ms. Aronson continues. The second topic Mr. Gessler wants to bring out, which has to do with the purchase by Lyle Menendez on the witness's presence of the camcorder that features so prominently in the prosecutor's case, which is the entire subject matter of the testimony of upcoming witness Brian Anderson, in order to show that this wasn't a sneaky or a secret purchase, in order to show the purpose for which it was purchased. The witness would testify that he and Lyle Menendez talked about getting a video recorder to record his tennis, and it was purchased for that purpose so it could be used to video the tennis practicing, and it was used for that purpose. And although technically that's not an issue in the case, until the people bring it in, technically SA wasn't an issue in the case until we brought it in. But the people were allowed to. Also ask Carlos Baralt questions about that. The third area, which I concede, is technically something that should come in during the defense case after my client testifies, but I am asking leave of court to ask the witness 2 questions, and only 2, concerning things that Erik Menendez told him just to save him from having to come back here. It cost him $400 to be here today. And those 2 things I started to ask were that Erik told him he was having nightmares during the time that he was coaching him full time. And the second thing is that on a day in November, Erik told Mr. Heffernan, or Dr. Heffernan, that was the first day that he didn't cry over his parents' death. Now, the other thing is, the fourth thing that I was allowed to ask one question about, but then further questioning was cut off by objection, was the appearance of Lyle's hairpiece, and the fact that it was not obvious, and that was really he said he didn't know he wore one until the last trial. And I just wanted to ask one follow-up about it. Did it appear natural? And that's about it. The only other thing is I don't need leave of court to do this, but I'm going to ask the witness a short series of questions concerning the sequence of events of the morning of 8/21, because his memory has been refreshed since this morning, and I believe he testified mistakenly about it. Mr. Gessler says, I would like to add one feature, Your Honor, as to the camcorder. Actually, I don't think it is an affirmative defense at this point. It is cross-examination as to the coaching of Erik through this period of time, and Mr. Heffernan and Dr. Heffernan, I believe, would testify that it was his idea to get a camcorder. It was very useful in the filming and training of Erik, and he was with Lyle when he got it. I think it's part of the cross-examination on the subject that has been gone into. Besides, it does refer to the tennis and the tennis practices and development of those two young men. Okay, the court says, what is the people's response? Ms. Nahara says, Your Honor, as to the first issue, eliciting from the witness the observations of the parents, I believe that that's both irrelevant and cumulative. Possibly it could be cumulative, but at this point it is irrelevant. I think that the court has started, I don't think it's relevant because you brought it up, that you had Perry Berman talking about Grant Walker talking about how the brothers were swearing at their parents. I think that the court has stated earlier that at this point, whether or not there was affection or terms of endearment or hugs by either the defendant or their parents towards one another really doesn't have a place in this trial at this point. So as to the purchase of the camcorder, I believe that the issue there, unless I am mistaken, is whether or not Jose Menendez was angry because the defendant Lyle Menendez was spending money without permission. It doesn't sound from the offer of proof as though Mr. Heffernan can state anything of relevance as to what Jose Menendez's opinion of this purchase was, and I believe That was the issue. I believe at some point it has been stated that the defendant, Lyle Menendez, had a reason, his own personal reason, for wanting to buy the camcorder. But I don't believe that goes to the actual issue of the camcorder or the issue that Mr. Anderson would be testifying to. As to the things Erik Menendez told him, number 3 in their category, I believe that would be self-serving hearsay at this point for which there is no adequate foundation laid. I also think that as to the November 1st stating that was the first day that he had not cried over his parents, that is also irrelevant. As to the 4th issue, the appearance of Lyle Menendez's hairpiece, that is completely irrelevant at this time. Mr. Gessler says, I'd just like to further respond on the issue that I am raising, the camcorder, Your Honor. It's not just Jose Menendez's state of mind whether Lyle Menendez was spending money without permission. It also goes as to whether or not Lyle was spending for his own purposes, one of the issues which the people have raised and presented the evidence on. And secondly, in a tape presented by the people with Detective Zoller in September in New Jersey, the subject of that camcorder came up and on the people's own evidence, and I think it's necessary to also corroborate the purpose for which Lyle said that it was being used. The court says, well, there was reference of the camcorder in the December 11th tape, or the tape between Oziel and the defendants. Let me back up. Not that tape of the, Ms. Abramson says 9/17. The court says of the September tape in New Jersey. Right. However, what it seems to me you intend to do is basically offer out-of-court statements of Lyle Menendez to prove why he did something. Mr. Gessler says, actually, in-court statements by Dr. Heffernan to prove why he did something. The court says, but these are out-of-court statements of Lyle Menendez recounted by Mr. Heffernan in here. Mr. Gessler says, no, they are actually statements by Dr. Heffernan in that it was his idea to get the camcorder. His idea, Dr. Heffernan's idea. The court says, okay, he can say that. I don't have a problem if he was there when the recorder was purchased and if it was his idea, but as far as any statements attributed to Lyle Menendez, that would be hearsay. Mr. Gessler says, that's fine, Your Honor. The court says, and would not be admissible. I think the area has been brought up by the people in their presentation of the New Jersey tape recordings and its relevant evidence. It might be beyond the scope, arguably, of the direct examination, but it does fall within the purview of the coaching relationship of the witness with the defendants. As far as the lack of warmth or the characterization by Miss Abramson of how the witness would describe the relationship or the atmosphere in the home, I don't believe that the testimony of Mr. Berman has opened up this area at this stage of the proceedings at least, and it would be irrelevant, and I will sustain the objection to that. Ms. Abramson says, well, Your Honor, there is another ground, which is the whole purpose of the people putting Grant Walker on the stand was to show the sweet, lovely parents and the horribly nasty children. I mean, I never understood. The court says, no, that was just describing one incident on one day, nothing more. Are you kidding me? It was totally prejudicial, and I don't even think it was true. He was very not credible. Ms. Abramson says, but the point is here we have a witness who knows a good deal more who contradicts that one incident on that one day. No, he doesn't. He doesn't contradict that at all, other than the facts of his testimony that it wasn't there. That's all he is saying. What? Ms. Abramson says, he has already testified he never saw either of them talk to their parents that way, never saw Mrs. Menendez ever offer up. The court says, I let you do that. I let you ask all those questions over objection. I know you did. Now you get to go further, and I am saying it's irrelevant, says the court. Ms. Emerson says, then I still don't understand why Perry Berman was allowed to talk about how warm and sweet Mrs. Menendez was towards her children. If the court is saying that that was an erroneous ruling, I would say fine. Everyone is entitled to make an erroneous ruling. The court says, are we? Yes, you are, says Ms. Abramson. The court says, I didn't realize you were that forgiving. Ms. Abramson says, not only I am, but God is. You are, but yes, you are. The court says, and the appellate courts? Ms. Abramson says, there is no question they would be that forgiving, Your Honor, none. But seriously, if there was a theoretical basis for that ruling, it's hard for me to understand why in the people's case we can't counteract evidence of the people. Exactly. If that ruling was a mistake, I won't ask again. The court says, okay, I am saying at this point, whatever question was asked of Mr. Berman and the answer he gave does not open the area for further inquiry in the people's case in chief. It's not relevant. What a dick. That's all I gotta say about Stanley Weisberg, wherever the hell you are. Ms. Abramson says, can I move to strike Mr. Berman's question and answer? Court says no. Well, you could move to strike, sure. It wouldn't work though. It would be denied, he says. As far as the proposal regarding areas that you indicate would only be relevant if the defendant Erik Menendez testified, I am going to sustain the objection at this point. We'll see what develops during his testimony. And regarding the hairpiece, that's already been asked. As far as I am concerned, the answer given is the only relevant answer, and anything further beyond that would be irrelevant at this stage. So I will permit you, even though you said you don't need leave of court to do so, you do since you finished your examination. Ms. Abramson says, I do to continue it, yes. The court says, I will allow you to finish your examination. She never finished of Mr. Heffernan on that area. Oh, yeah, she did. She said she did, and except she had some other questions. I forgot. Um, the court says, I will allow you to finish your examination of Mr. Heffernan on the area of the August 21st sequence of events, since you have been able to clarify that with him. And whichever counsel wants to go into the camcorder, I will permit it, with the understanding we don't get into hearsay statements of the defendants. So let's have the jury come back. Must be nice to sit on your throne of righteousness, Mr. Weisberg. I really, I already thought he was biased in the first one, but it really comes out in this one. And maybe it's because we didn't really get to listen to all the sidebar conversations and stuff. We didn't hear all the oral arguments, and this time around we are. But you can really tell, like, his tone, he's always been, like, snippy and rude with Leslie, I think, Ms. Abramson, but I think it's worse this time around. What do you guys think? Is it possible that he's worse? All right, let's get back into it. So, the court says, okay, the witness is back on the witness stand. You have been variously referred to as Dr. Heffernan and Mr. Heffernan. You have a PhD, is that correct? The witness says, yes, I do. Court says, okay, we will refer to you as Dr. Heffernan then. You may continue your examination. Mark Heffernan, the witness on the stand at the time of the adjournment, resumed the stand and testified as follows. Ms. Abramson continues her cross-examination. Dr. Heffernan, this morning I asked you some questions about your recollection of the events of the morning of August 21st. Do you remember that I asked you that? Yes. And over the lunch hour, did we have a discussion about the step-by-step sequence of events after you brought Lyle and Erik Menendez back to your home? Yes. And do you have a refreshed recollection about that sequence of events? Yes. All right. Could you tell us then, after you brought them home, did they appear to go to sleep, go to bed? Ms. Nahara says objection calls for speculation. The court says, as phrased, it's ambiguous as to how he would know this. Because it appeared that they went to bed? Like, why is that ambiguous? I don't understand, but okay. Ms. Abramson says, did you show them a place where they were going to be allowed to sleep in your home? Yes. And to the best of your knowledge, did you assume that they went to sleep? Yes. And when you woke up in the next morning, did you see them? No. Did they arrive at your house sometime after you woke up? Yes. And do you remember that your wife, in fact, talked to you and and to them about getting special things in for breakfast? Yes. And were such things purchased? Takeout, breakfast foods, muffins, and things like that? Yes, they were. And do you remember Eric and Lyle Menendez having breakfast with yourself and your wife at your home that morning? Yes. And after breakfast, did you go back to the Elm Drive home with Eric and Lyle Menendez? Yes, I did. Thank you. Ms. Abramson says, I have nothing further, Your Honor. The court says, all right. Mr. Gessler is going to begin his cross examination. Just a few more questions, Dr. Heffernan. Regarding Lyle Menendez's tennis playing abilities, was he just kind of a weekend player who would like to get better, or did he have more talent than that? He had more talent than that. Could you describe the level of talent that he had? Ms. Nahara says objection, irrelevant, overruled. Well, he was a very strong athlete, very strong body, very determined when he trained. When he came out to play, he really usually played very hard, and he had fabulous endurance, really could work a long time, and, the most I had ever seen anybody train. I trained him one time for 4 hours in a row, and he worked very hard. He pulled a muscle in his shoulder and was out for a month, but he was very determined and had some wonderful capabilities, I think. Did you describe his abilities to the district attorney as being able to go all the way? Yes, I thought he had a good shot. And when you say go all the way, what did you mean? I mean, I thought he could have been a highly world ranked player if he was stick to itive and creative and created the opportunities to get him there. Now, did you work with him also in November, December, and January? So November and December of 89 and then January of 90. I don't think January, maybe January, definitely in the fall. And that again was before the contract was actually signed, but with the understanding that the contract was what you were working under. Yes. Is it fair to say that during that period of time he was still somewhat torn between whether to go into business in the East or to develop his tennis skills to the ultimate? I think that would be fair to say. So sometime during that period, they moved into the Marina City Club, Eric and Lyle? Yes. And do you remember if that was sometime around the end of October, early November? I believe it was. And you have described some of the facilities there as being a gym. Is that where the weights are? Yes. And was there a good weight training facility, that is, in the machines and weights that were available? Quite good. I mean, there's better, but there's a lot worse, yeah. Do you feel it was adequate for the program that you were setting up? Yes, especially the person that they had hired to work with on the weights, and he didn't need a lot of machines. So that's the Olympic guy that you had mentioned? Yes. Now, in addition to the gym, and I think you said there was a pool there? Yes, there was. And was there something in the water or use of the pool that also helped train a tennis player? Absolutely. And how did you use that facility? Well, we would do different resistance exercises. It was good for your aerobic capacity. If you wanted to do shorter work, it was good anaerobically. So we would be working harder, shorter duration type of activities with less oxygen at the higher levels as basically anaerobic support. So we worked with resistance, running in the water. There's a lot more resistance there. When you say anaerobic, what do you mean? Basically, the tissue's abilities to work without oxygen, where the oxygen has been used up in the tissue per unit type, and you work it on the reserve of the muscle fiber strength. You don't do it very long, obviously, but you get to the point where you are working a little bit without oxygen. I am not an exercise physiologist. I don't want to elaborate any more than that. But basically, does that help bring you back stronger afterwards than you were before? Objection, irrelevant, overruled. Not necessarily stronger afterward. I think it teaches you to work anaerobically. If you are training anaerobically, you have the capability of working anaerobically down the road. There is specific training. And is that one of the things that helps make a world-class tennis player as opposed to a non-world class? Absolutely. Now, Were there also some bicycles that you had Lyle and Eric get as part of their training? Yes. And how did that work into the regime? Well, or we do distance rides in the morning, and basically this was the early part of the training schedule. So we were doing some endurance activities to build the muscular tissue and red blood cell capability of using oxygen better. So early on in the training regime, such as this, they get used to using their oxygen better, so later on they can put more load on their body later on. We could take long bike rides, and as competitive as we all are, we would end up racing each other, but long distance. We would ride for half an hour out and half an hour back. It was strenuous. Okay. So this was more of a training bike ride as opposed to going out and hearing the birds sing. Absolutely. Ms. Nahara says, Your Honor, I would object to any questions about training as irrelevant. Overruled. Is he not their coach? Like, why would that be irrelevant? Mr. Gessler says, Now, at some time, probably late January, Lyle Menendez left and went back east to go into business. Yes. Ms. Nahara says, I object. I believe it misstates the evidence, the witness's testimony. The court says, sustained. The answer is, well, back up. He has answered yes, so objection is overruled. Next question. Mr. Gessler says, Now, incidentally, during the time that you knew him, did you ever know Lyle Menendez to say anything negative to his father? Not to my knowledge. Nor about his father to you? No. How about to his mother, to your knowledge? Not that I can really put my finger on. And did he ever say anything negative to you about his mother? Not really. If anything, just that she wasn't happy about the move to California. So he doesn't complain about his parents. He never talks back to his parents. This guy has been with him for, serious, intense, like sessions and stuff, and nothing. He doesn't, there's this guy contradicts Grant Walker's testimony, the pool repairman. All right, Ms. Nahara says I would object to anything as hearsay beyond no. Court says sustained. The rest of the answer is stricken. Mr. Gessler says now, was there a man in approximately July 1989 where you were back in the New York City area? Yes. And was that for a tournament you were playing in? It was. During that period of time, did you make any suggestion to Lyle Menendez that a camcorder would be very valuable in your training to them? I probably made that request earlier on than that. So even earlier. Do you remember when you first made it? I might have made it very early in our association because I believe in video coaching. How is that useful to you? Objection, irrelevant, overruled. Well, it gives you some objective observation of the results. It allows them to see firsthand what they're actually doing rather than what they think they're doing. It allows me to see in an objective stance what they're actually doing rather than what I am perceiving or hoping they're doing. So it allows us to see the value of the training firsthand and I think more honestly. So, do you look at the video along with your students then together? Yes. And it's part of your coaching, is it? Yes. Now, in July, were you with Lyle Menendez when he purchased the video camera? I was. Objection assumes a fact, not an evidence. Overruled. Mr. Gessler says, where did this take place? Was that in New York City? It was. Was this a place where you knew where you could get a good deal? Well, there was this certain areas of Fifth and Seventh Avenue that they have a lot of electronic shops. So if you shop them, you could get good deals. Is that what you did on this occasion? Yes. So you remember about how much that video camera cost? Between 800 and 1,000 in that area. Thank you. I have nothing further, Your Honor. Any redirect? And yes, there is some redirect. Ms. Nahara says, Sir, did the defendant, Lyle Menendez, Was the defendant Lyle Menendez the first person to approach you about Eric Menendez's tennis coach? I don't think approach is the word. It was probably discussed. Yeah. Thank you. So would you say that the defendant Lyle Menendez was the first person to discuss with you being Eric Menendez's tennis coach? I think that he thought it would be a good idea. And after that, did you ever discuss this with Eric Menendez? I'm sure I did, yes. And did he also feel that it would be a good thing for you to be his tennis coach? I guess so. What was the impression, or was that the impression that you had from him and your discussion with him? Well, I think so. Or I wouldn't have been his coach ultimately. Now, is it fair to state that it wasn't Jose Menendez who was the first person to approach you about being Eric Menendez's tennis coach? Is that right? That's right. And is it also fair to say that Kitty Menendez was not the first person to approach you about being Eric Menendez's tennis coach? Is that right? Yes. And did it appear to you when you coached Eric Menendez that he seemed to like playing tennis? Yes. Did he appear to enjoy it? Yes. Now, after Jose Menendez had his life taken, did Eric Menendez continue to play tennis even though there was no one making him? Ms. Abramson says, I'm going to object to the form of the question, Your Honor. Assumes facts not in evidence. The objection is sustained. Blah. Getting tongue-tied again, sorry. Ms. Abramson says, yes, thank you, Your Honor. Ms. Nahara says, after Jose Menendez had his life taken, did Eric Menendez continue to play tennis? For how long a period? I mean, he didn't play immediately after their lives were taken. But sometime a few months after his parents. Oh, absolutely. Let me finish the question. A few months after Jose Menendez's homicide, did Eric Menendez once again play tennis? Yes. And after Kitty's homicide, did Eric Menendez a short time later continue to play tennis? What a dumb question because they were taken at the same time. But yes, Ms. Abramson says, Your Honor, I think that's a very confusing question since they were killed at the same time. The court says, well, it's understood they were, so objection overruled. Thank you, Your Honor, says Ms. Nahara. And she asks another question. And, sir, to the best of your knowledge, was anyone forcing Eric Menendez to play tennis? No. Now, when you coached Eric Menendez while he was in high school, did you coach him, is it fair to say, an average of approximately 2 hours a day? No, that's not true. What would you say would be the best average? I would say 10 hours a week, 8 to 10 or 12. It varied. Yeah, I would say 8 to 10 or 12 hours a week, but not 2 hours every day. I'm just going by an average. What would you say is the average? I'm sorry, did you coach him every day? No. Okay, how many days a week did you coach him? Between 3 and 7. Okay, and between the 3 and 7 days a week that you coached him, what was the average you would say, the average number of hours per day? When I coached him, it was usually a 2 hour session, sometimes an hour, sometimes 4 hours, or 3 hours. So I'd say 2 is a good average. Maybe 2.5? I don't know. Okay, and as your records reflect, sometimes it was only 1 hour, and sometimes on an occasion, I believe it went as high as 4 hours. Is that right? That's right. And is it a fair statement to say that you are not a cheap coach? I'd say that's fair. Ms. Aronson says, I would object to the form of the question. Cheap is definitely relative. The counsel says, all right, counsel, let's not argue. And vague. Court says, do you understand the question? The witness says, yes. Court says, objection is overruled. And the witness says, no, I am not cheap. Ms. Nahara says, and in fact, your rates are competitive for the level of coaching that you provide. Is that true? I would say so. And it would be possible to purchase the services of tennis coaches that were more inexpensive than yourself. Is that right? Yes. And is it a fair statement that you were costing Eric Menendez's dad, Jose Menendez, thousands of dollars over the years that you had trained him, the year that you had trained him? Objection, Your Honor. The witness has testified to a year. Court says, are you talking about the year of 1989? Ms. Nahara says, 1989 to August of 1988 to August of 1989, in that time period. You do understand the question, or I do. I would say that's fair. And you testified on cross-examination that in response to a question by Ms. Abramson that they wanted him to be invested if you were invested in. Do you remember that statement? I do. And is it fair to say their dad, Erik Menendez's dad, invested thousands of dollars in him or in you to coach him? Yes. And it was your impression that his dad, Erik Menendez's dad, wanted to see his son invest in himself as well. Ms. Abramson says, Your Honor, I'm going to object to the question as calling for speculation. Court says, well, I think the question was asked and he was asked, what did you mean by invest? And he gave an answer this morning, did you not? Witness says, yes, I did. The court says, okay, I think that's already there, what he meant. Ms. Nahara says, I beg your pardon, Your Honor. I think his answer is there. Okay. What does that mean? Like he already answered it? Okay. And while you were coaching Erik Menendez in high school, was it your understanding that he wanted to play tennis in college? Yes, I think so. And did you have conversations with the defendant, Erik Menendez, about his playing tennis at UCLA? I'm sure I did. Did he, meaning Erik Menendez, tell you of his plans to go to UCLA and play tennis? Yes. And do you remember what he said about going to UCLA to play tennis? No, I don't. I mean, generically, I can come up with something, but I don't know what exactly he had said. Do you remember generically any of the conversations that you had with him? Yeah, I think that UCLA is probably in the top 5 of the nation's schools, so he didn't have a scholarship to play on the team, but he was good enough to walk on the team and to see if he could make the team. And he talked to the coach at the school about that, and he was welcoming Erik to come and try out, and he was going to have to play well to make that team. Did he wish to make that team? Yes, he did. And was he working with you with the express goal and desire to make the UCLA team? No, not the express goal and desire. Was it a guiding goal and desire? Yeah, I think he wanted to play professional tennis, and that was one of the stages of development that he had to go through. And it was your understanding from your discussions with the defendant Erik Menendez, that it was his desire to be a professional tennis player. Yes. That was kind of his dream or goal in life. I think so, yeah. It wasn't really. I thought he wanted to be an actor or a teacher or something. I know he's teaching now in prison. He's teaching all those courses. He's got many, many courses. He teaches a week, sometimes like at least a course a day. All right. And did he pursue the goal after Jose Menendez and Kitty Menendez's homicide? Yes. Did Erik Menendez ever tell you that his dad might not let him play on the UCLA team? Ms. Abramson says, object to that, Your Honor. The court says, do you have any legal objection? It's calling for hearsay. Sustained. Is this being offered for the truth of the matter asserted? Ms. Nahara says it goes to the defendant's state of mind. Ms. Abramson says, well, then it's a violation of discovery rules, Your Honor. The court says, okay. Do you have other questions of the witness? Yes, Your Honor. Okay. Okay. Now, you stated on cross-examination that on occasion you had seen Jose Menendez watching you coach Erik Menendez. Is that correct? That's correct. And in all that time, my understanding of your testimony is that you had never seen Jose Menendez's, Erik's dad, you never seen Jose ever scream or yell at him. Is that correct? That's correct. Did you ever see Jose Menendez cuss? Ms. Abramson says, I'm sorry, didn't hear the last word. Did you ever see or hear, I should say, Jose Menendez cuss? I don't believe I did. No. Now, you testified on cross-examination that you believed that you played tennis with Erik Menendez on Friday, August 18th, 1989. Do you remember that? Yes. And was there a reason why you thought it was Friday, August 18th, 1989 that you played tennis with Erik Menendez? Yeah, I believe that the next day they were going fishing because I didn't have these guys on a regular schedule. I found out day to day if I was seeing them the next day for the most part. Sometimes we would organize weeks in advance, but so I thought it was the next day that I believed it was the next day that they were going fishing, and I said, "Well, what about Sunday?" And they said, "Well, let's talk." Something like that, because that's usually what we did. Now, because you testified that you thought that you were playing with the defendant, Erik Menendez, is that correct? That's correct. And when you were playing tennis with him, and when you had this conversation with him, what was his demeanor that day? Nothing comes to mind out of the ordinary. I mean, he had different emotional responses on different days, but nothing that was extraordinary. So, just calling your attention now to August 18, 1989, is it your testimony that there was nothing out of the ordinary about his demeanor? Ms. Abramson says, I'm going to object. That misstates his testimony. He said nothing comes to mind. Overruled. What was your answer? Witness says, I would say, yeah, it wasn't extraordinary. Yes. Do you know if Erik Menendez played tennis with people other than yourself? He played tennis with other people, yes. And do you know if the defendant Lyle Menendez played tennis with people other than yourself? Absolutely. And when you say absolutely, have you observed this? I set matches up for them. Do you know if the defendant Lyle Menendez played tennis with other people at his home at 722 Elm? I would imagine so. When I was coaching them, when Lyle was home, especially, he had a friend, actually, that stayed for a month and trained with him. So, sure, that would be fair to say. And you testified on cross-examination that around January of 1989, you were aware that the defendant, Lyle Menendez, went back to Princeton. Is that correct? That's correct. And when he came back, you would play tennis with him. Is that correct? Yes. How often do you remember him coming back from Princeton from January of 1989 to the beginning of summer? The court says of 89, and Ms. Nahara says January of 89 to the beginning of the summer. Well, he was in school, so not often. Was it once a month? I can't say for sure. I can't remember that. But you do recall him coming back? Yes. During that semester? Yes. Now, Miss Abramson just asked you recently about the events that took place on August 21st, 1989. Do you remember those? Yes. Okay, and do you recall what time you got up in the morning of August 21st, 1989 after you came back from the police station? No, not exactly. Do you have an idea? Yeah, between 7 and 8, I think. Okay. And when you got up between 7 and 8 a.m., were the defendants at your house? No, they weren't. Did they return? They did. When they returned, did you ask them where they had been? I guess I did. I'm not sure I did, or I'm sure I did. Do you recall what they told you? I don't exactly recall that. Do you think it would refresh your recollection to look at a report prepared? Probably. Your Honor, may I approach the witness? The court says, why don't you show counsel what it is? Ms. Nahara says, may I approach the witness, Your Honor? Yes. Thank you. Calling your attention to this document, and specifically calling your attention to paragraph 1, 2, 3, 4, starting at 3 and going to the end, would you read that and tell me if this refreshes your memory? Tell me when you're through reading it. Okay. Thank you, sir. And does that refresh your memory about the events of August 21st, the memory thereof? Yes. Okay. And at some point, did the defendants return to your house? They did. And did they tell you where they had returned from? From their house. And that being 722 North Elm Drive? Yes. And did the defendant Lyle Menendez have a conversation with you? He did. And did he tell you something about his house, 722 North Elm? I'm going to object as hearsay, Your Honor. Overruled. That he wanted to go back to the house. I can't remember exactly what I said in that transcript. He wanted to go back before the police were there to do something. And do you recall whether or not he told you why he wanted to go back into his house at 722 Elm? I don't recall that. No, I'm not sure if he said into it or back to the scene. I can't remember that. Did he discuss was your wife present when this took place? I can't remember. I'm not sure. Does your wife work in an attorney's office? She does. And did the defendant, Ms. Abramson says, Your Honor, I would object at this point and ask to approach. The court says, on this question? Yes, on this question and on the one that I anticipate is coming after this. The court says, okay, let's do that, and we will talk about the other question that was held in abeyance also. We'll do that in the hall. All right. So now the following proceedings were held outside the presence of the jury. Court says, okay, what was the question going to be? Ms. Nahara says the question was going to be basically I was going to ask him about this conversation that he had with Lyle Menendez, where Lyle Menendez told him that he wanted to get back into the house before the police were done with the investigation, and he wanted Mark's wife, who works in an attorney's office, to contact a lawyer to get him into the house. And this is right on what counsel was asking him about in terms of the events that morning. The court says, okay, yes. Ms. Abrams says, okay, let's see. We can go down the laundry list. Number one, there was never proffered, the statement of Lyle Menendez was never proffered in pretrial proceedings. Number two, I think it's prejudicial that he is asking about a lawyer in my client's trial. Yeah, that's unfair. You're not supposed to be talking about lawyer, client privilege and whatnot. Number three, the people didn't elicit any of the statements during their direct of the witness, and my asking the chain of events does not open the conversations, and for all of the above reasons, we object. The court says, okay. And Mr. Gessler says, I would join in those objections, Your Honor. It's also hearsay, and the court says, how is it hearsay to your client? Just out of curiosity, how does that work? Mr. Gessler says the same way as to how other objections as to what my client said has sometimes been sustained and sometimes not. The court says it depends on who asked the question, and if you ask the question, it could be hearsay, and if the people ask the question, it could be an admission. Well, this doesn't seem fair. Mr. Gessler says it could be, but it isn't. You can't ask every question hoping that something is going to be an admission. The court says no, but in the context of this sort of questioning, it sounds like it is an admission. It sounds like it is an admission would be. Mr. Gessler says, at any rate, we don't have a determination by this witness that his recollection is refreshed as to the area either. Ms. Abramson says, right. Court says, okay. Well, I'm certainly preventing the prosecutor until we see if she can establish that. I think it is opened up by the nature of the questioning of finishing off the sequence of events. What a dick. Ms. Abramson says it was opened up by bringing out activities. The court says that he wanted to go back. Lyle Menendez expressed the opinion that he wanted to go back. Ms. Abramson says, I said went back with him. That's all I asked. He went back with him. The court says this is something different, that he wanted to go back for the particular purpose. And Ms. Abramson says, that's right. It is different. That's right. And it's Lyle Menendez's statement and Lyle Menendez's purpose and not my client's, and that's my whole problem. The court says, first of all, I don't know whether Erik Menendez was present when it was said. Ms. Abramson says whether or not he was present, it's not the statement. It's not his statement. The court says, but it could be as to Lyle Menendez. Ms. Abramson says, but Your Honor, you do understand that we are in a joint trial with one jury. The court says, I have that impression. Ms. Abramson says, but as at some point, all the things that Lyle Menendez said that are coming into Erik's jury is fact. Facial expression meaning not fair, but not fair. What? Facial expression meaning not fair, but not fair. I don't like to say not fair. I sound like Marcia Clark if I say not fair, says Ms. Abramson. Court says, what I would do if the witness has recollection of it, I would limit it to Lyle Menendez. Ms. Abramson says, I know. The court says, I don't think there's any problem involved in the statute of limitation. What was the area of inquiry that you had an objection to about UCLA and the father? The question was, did your client ever say to the witness that the father didn't want him to go to UCLA? Ms. Abramson says, that's my objection. It's a statement from the father that he didn't want him to go to UCLA. I don't think they have any grounds to ask that question. They don't know if this witness has that explanation. Ms. Nahara says, it was something that Erik Menendez testified to in the first trial, that Erik Menendez basically had been told by his father that he might not let him play on the UCLA team. And as to the questions I wanted to ask him and didn't get a chance was whether or not he had told someone else. My understanding was he did, but I want to make sure of that before I state that on the record. The court says that he did what? That he told someone else this. Who? Whether or not it was Heffernan, I don't know. I'm unclear. The court says, who said that Erik Menendez testified in the first trial that he had said that to someone else? Ms. Nahara says, my understanding is that Erik Menendez testified in the first trial that his father told him he might not let him play at the UCLA team. The court says, yeah. Ms. Nahara continues, what I want to ask this witness is whether or not Erik Menendez ever told him that. The court says, why ask him? Ms. Nahara says, because this is the witness who would know. This is the guy who was training him to play professional tennis at UCLA. If that were to come up, this is the man to ask. The court says, what you're trying to do is corroborate Erik Menendez's testimony. Is that what you're saying? Actually, I do want to corroborate that particular piece of evidence that his father might not let him play on the UCLA team, and he was working at that for months. The court says, at this point, it doesn't seem to be relevant if the defendant hasn't testified about it. I don't know why you want to corroborate his testimony on the subject, but if it comes up later or later on that you need to and can talk to the witness and verify that's his testimony, call him back. Ms. Nahara says, thank you, Your Honor. That's what we will do. The court says, and as far as this question about what Lyle Menendez said, I will have him look at the reports and see if it refreshes his recollection. If it does, then it would be a statement limited only to Lyle Menendez. Ms. Nahara says, thank you. The following proceedings were held in open court. The court says, all right, let's proceed. Ms. Nahara says, thank you, Your Honor. Did the jury come back? Not yet. Not yet. All right, so Ms. Nahara says, Mr. Heffernan, yes. Okay, I'm sorry. I do not mean to be impolite. It is Dr. Heffernan, is that correct? It is correct. And I apologize for any slight that it may sound like. Going back to what you were talking about before the little break there, once again, I am going to ask you to read this paragraph again. Okay. Now, sir, for the record, let me ask you, did this refresh your recollection as to the events of August 21st, 1989? Some of them, yes. Okay. And going to what you recall, do you remember the defendants, Erik and Lyle Menendez, returning to your house? Yes. And at that point, do you remember having a conversation with the defendant, Lyle Menendez? Yes. Excuse me, Your Honor, the witness is saying yes, but shaking his head no. The witness says, I just don't know exactly what happened. I read it here, or I read it there, and to be honest, I can't remember, but if I said it, I did. If I said I did it, I did it. That's what I'm responding. So that's how I'm responding. Okay, great. He's a fun witness. He's kind of fed up with the questioning, I think. Court says, right now, if you don't remember it, just say that. The witness says, I don't remember a lot of that stuff, to tell you the honest truth. That just totally discredited him for the most part of most of his testimony. Ms. Nahara says, now, having read this, do you remember talking to Detective Zoller and Linhart about this event? Yes. And do you remember this conversation? Do you remember having a conversation with them on February 28th, 1991? No. Do you remember having a conversation with them sometime in 91? Yes. Is it fair that you don't recall the date? Yeah, that's fair. Now, when you had the conversation with them, did they ask you questions about the events of the morning of August 21st, 1981? I think they asked me everything. Okay, and at that time, did you give them all of the information as you knew it? Yes, I believe I did. And the information that they received from you, to the best of your knowledge, was it correct? Yes. And were you trying to be as accurate and truthful as possible at that time? I swore to tell the truth. And anything that you may have told them on that day, would that be the truth that as you knew it? Yes. Now, going back to what was asked on cross examination, you said that you saw the defendant, Eric Menendez, in a hotel room. Whoops, sorry. Is that correct? In New York? Yes. And was he alone or was he with anybody? Ms. Abramson says, objection, Your Honor. What's the legal basis? Irrelevant. Overruled. Yes, he was. And who was he with? He was with a bodyguard. And do you know what the bodyguard was there for? Ms. Abramson says, we object to that as calling for speculation or hearsay. Sustained. Objection sustained. Ms. Nahara says, was the bodyguard with the defendant, Eric Menendez, the whole time he was with you? You mean right behind him or in the same room? In the same area. In the same area, yes. And you testified that at some point the defendant, Eric Menendez, spent the night with you. Is that right? Yes. And what happened with the bodyguard? He sat outside the door in the hall. He sat. We got him a nice chair. When you say he sat outside the door, that would be the door to your hotel room? Yes. And the next morning, did you see the defendant, Eric Menendez, leave? I think we had breakfast together, so he left. We walked down to the lobby together. And what about the bodyguard? What, if anything, was he doing? I don't know exactly at that time what he was doing. I know he was in the area, but he wasn't with us. But I was going to ask you, was he still there? I think he was. Now, after this, after you saw Eric Menendez in New York, you testified that you started training he and Lyle Menendez. Is that correct? That's correct. Now, do you remember, as you sit there now, whether it was September or October or November that you started training Eric and Lyle Menendez? I don't exactly recall. I would imagine it was October. And this would be October of 89? Yes. And during that time, from October of 89, from that time when you did, when did you stop training Lyle Menendez? Well, I would say around the new year. So would be around January of 1990. I would say so. I mean, it was more periodic, if anything, after that. Now, from October of 1989 to January of 1990, was the defendant Lyle Menendez traveling back and forth from New Jersey? I believe so. And was he involved in business ventures, to your knowledge, in New Jersey? Yes. And did this appear to be taking up much of his time? I think so. And he was launching some business? He was launching some business ventures, is that correct? Yes. And was he also buying property back in New Jersey? Mr. Gessler says, I will object to that. It's beyond the witness's knowledge, Your Honor. The court says it's also beyond the scope of the direct examination sustained. Ms. Nahara says, and is it a fair statement to say that from October of 89 to January of 1990, Lyle Menendez was not as involved in the training program as Eric Menendez was? That's fair to say. And is it fair to say that Eric Menendez was becoming basically full-time devoted to this particular training, whereas Lyle Menendez was not? Yes. So, when you testified to all the various intensive training that was being done on a daily basis, is it fair to state that that more applies to Eric Menendez than Lyle Menendez, especially in the last month or so and a half? And you said at some point you were of the impression that Lyle Menendez was trying to choose between business and tennis. Is that correct? That's correct. And was it your impression that Eric Menendez had chosen tennis as a career? Yes. And did that seem to be a driving goal for him? I think so. Now, you stated as a result of cross-examination that one of the things that the defendants got involved in was weightlifting. Is that correct? That's correct. And you stated that they hired an Olympic class weightlifting coach. Is that correct? They paid for him. I hired him. You hired him. I interviewed guys. And who actually paid for him? They did. They, meaning both defendants or one defendant? Well, I don't know who made the check out, but collectively they paid for him. And was this during that, or was this period that they were paying this Olympic class weightlifting coach? It was the fall of that year and up until we went to Israel, Erik and I. So this would be from the fall of 89 to February of 1990. Yes. And this Olympic weightlifting coach, was he expensive? Ms. Abramson says, objection, Your Honor, calls for speculation, overruled. He was, I guess, moderately expensive, yeah. Ms. Nahara says, I beg your pardon? Moderately expensive. Moderately expensive? That's the relative word, expensive. Was he one of the better weightlifting coaches? Well, I don't know if they were judged, but I thought he was very competent. And did the fact that he was considered competent, Ms. Abramson says, Your Honor, I'm going to object at this point since this is a decision based on relevance as to who made the decision about the person being hired. The court says, I haven't heard the question yet. Let me hear the question. Ms. Abramson says, this whole line I object to. The court says, I want to hear the question. Ms. Nahara says, the question is, this individual, the fact that you considered him very competent, did this translate into him being paid a good wage? Ms. Abramson says, objection, Your Honor, as to 350, 352. The court says, I think he has already answered the question as to his evaluation of the relative expenses of the individual. Ms. Nahara says, okay. And at the time that this individual, who was this individual, by the way? What was his name? I can't remember now. It was 5 years ago. He moved right after that. Actually, I thought he was good enough. I worked with him for a couple of months myself, and then he moved to Albuquerque, I believe. When you worked for him, did you work with him for a couple of months? Yes. When you worked with him for a couple of months, did you pay him? Yes, I did. How much did he charge an hour? Ms. Abramson says, Your Honor, I will object to any further questions about this under 350, 352. The court says, sustained. Ms. Abramson says, thank you, Your Honor. Ms. Nahara says, now, you said also in direct response to cross-examination that the defendants had nutritional profiles done by a holistic doctor. Is that correct? Yes. Was this an expensive procedure? Yes, it was. Objection, Your Honor. Same objection under 350 and 352. This is the witness's decision of what should be done. The court overrules that. Ms. Nahara says, and your answer was, it was expensive. And who paid for this holistic doctor? Same objection, Your Honor. Overruled. Erik and Lyle paid him. Now, you also said that you had them buy some bicycles. Is that correct? That's correct. And what are we talking about here? What kind of bicycles? I guess racing bicycles, not necessarily competitive bicycles, just racing bicycles that they could train on and, good quality bicycles. Do you know how much they cost? I don't know. And did the defendants pay for these bicycles? Yes, I am sure they did. One last question, or a couple of questions here. When you saw the defendant, Erik Menendez, in New York and he had the bodyguard with him, did you ever ask him why he had the bodyguard? I don't recall. Thank you. I have nothing further. And we move on to recross. All right, so this is Ms. Abramson for Erik. And she says, do you remember Erik telling you it was Lyle's idea that he have a bodyguard? Objection, hearsay, overruled. Yes, I think that's right, says Mr. Heffernan, Dr. Heffernan. Ms. Abramson says, and you have made that statement before in interviews with the police and the prosecutors, correct? Correct. Now you had what you believed was a serious commitment from Erik and Lyle Menendez to work on their tennis with you, correct? Correct. And you suggested to them that they needed a weight training coach, right? Yes. and they took your suggestions? Well, I didn't feel I was competent enough in that area. I mean, I know about physical training, but not like this man. And you knew that they needed this kind of training to make the work that they were doing with you and the money that they were paying you worthwhile. Yes. And of course, they followed your advice. Yes, they followed your advice about that. They followed your advice about the nutritional assessment, correct? Correct. They followed your advice about a nutrition program. Yes. They followed your advice about methods of working out, such as with bicycles. Yes. They were obedient and took your advice, right? I would say that's true. Would have been counterproductive for them to have paid for all that money for you and then not followed your advice, wouldn't it? Objection calls for speculation, overruled. Yes, I would think that it would be counterproductive. Ms. Abramson says, if Erik wanted to get on the UCLA tennis team that fall of '89, he would have had to go to school there that fall, wouldn't he? Yes. By the time Erik decided to work with you full time, it was too late to go to school that semester, wasn't it? Probably. Mr. Harris says, objection calls for speculation. I believe he has no personal knowledge. Objection sustained. He answered. Perhaps you can lay a foundation. Ms. Abramson says, you know that UCLA at that time started up at the beginning of the fall, correct? Yes. And is it your recollection, Dr. Heffernan, that in fact your rigorous training with Erik started on or about November the 7th? I would say that would be right. I'm not sure about the times, but that sounds right. Ms. Nahara says, I object. Make a motion to strike. No foundation. The court says sustained. The answer is stricken. Ms. Abramson says, does it sound like it was the beginning, to the best of your recollection, was it the beginning of November following some preliminary discussions that you actually started this full-time intensive training with Erik? I would say that's right. And was it at the end, then, of October that the discussions occurred concerning your being his full-time tennis coach? Yes. And it was, isn't it true, then, that it was at the same time, end of October, beginning of November, that Erik made the commitment to try and become a professional tennis player? Made the commitment to you? Yes. And it was your understanding that UCLA began its semester in either late August or early September. Objection, no foundation, lack of personal knowledge. The court says, can we have a little more foundation as to how he would know this? Were you familiar with the schedule at UCLA, at least vis-a-vis the tennis team and getting on the tennis team tryouts, those sorts of things? Yes, I was somewhat familiar with that. If Erik had wanted to be on a team, would he have had to try out early in the semester? I'm going to object. Lack of foundation. Do you know that? Asks the court. The witness says, yeah. Usually the team meets and they don't have necessarily strict formal practice in early September, but they do have practices and they play each other. And it's starting. There is a walk-on time, for example, for the guys that walk on, and usually the winner of the tournament or the top two players get to play on the team. Ms. Abramson says, and that's done in early September? Well, that's done in, yeah, I would say early fall. I'm not exactly sure what the date is, but certainly before the end of October? Yes. So the opportunity for Erik to have gone to UCLA and made that team has passed by the team he made the decision to work towards being a professional player with you? Yes. Did you ever discuss with him why he decided not to go to UCLA that fall? Objection, irrelevant, overruled on that ground. Objection, hearsay, sustained. Well, Your Honor, given the people's inquiry, I would ask leave to just know if there was a discussion without bringing out the contents of that at that time. Ms. Nahara says, and it's irrelevant. The court says you can do that in talking to the witness yourself. Ms. Abramson says, I can't talk to the witness in front of the jury except now, Your Honor. The court says, do you want to lay some sort of foundation? Ms. Abramson says, yes. The court says, do you understand the question without going into the contents of what was said? Just whether there was such a conversation on the subject. The witness says, I am sure there was. Yes. Ms. Abramson says, and do you know when that conversation with Erik about why he wasn't attending UCLA took place? No, I don't. Do you know if it was before or after you started working with him full time? I would have to say before. Miss Abramson says, I have nothing further, Your Honor. Thank you. All right, Mr. Gessler says, I have a couple questions, Your Honor. So we're going into recross for Lyle. Dear or Dr. Heffernan, it was in approximately the first of the year of 1990 that Lyle began to go back east and pursue business interests? Yes. And was it in November and December when he was training with you? Yes. And that's when these competitive bike rides you have told us about took place? Yes. And the weight training took place? Yes. And the 4-hour session on the court that you have told us about with Lyle Menendez? No. When did that take place? That was before. That probably took place before the homicides. All right. But other training sessions on the court, that is the tennis court, did take place with Lyle Menendez throughout November and December with you? Yes. Thank you. Nothing further. Anything else? Miss Nahara does have some redirect. Ms. Nahara says, Sir, just to clarify one area, you didn't make the defendants hire a weight training coach. Is that correct? That's correct. And you didn't make them hire a holistic doctor. Is that correct? That's correct. And you didn't make Lyle Menendez buy a camcorder. Is that correct? That's correct. And with regards to the defendant, Erik Menendez, he had previous to your working with him as a full-time tennis coach, he had expressed to you that his goal was to play tennis. Isn't that correct? That's correct. And did he express to you the goal that he wanted to be a professional tennis player? I think he did, yes. And was this back when his parents were still alive? I think it would come up as more of a dream at that stage, but it probably came up, yes. Ms. Nahara says, thank you. Nothing further. The court says, anything else? And yes, there is more. Further recross by Ms. Abramson. All right, so Ms. Abramson says it was also part of the plan that he was going to go to UCLA and play tennis there first. At this stage, it was. And that would have been good for him for a potential professional career to play at UCLA on a top team against top players. Absolutely. So the plan was did he ever talk to you about other things he wanted out of college besides playing on the tennis team? Oh, I'm sure he did, yes. And did he seem interested in going to college? Yes. Interested in learning about things? Yes. Mr. Harris says, I'm going to object at this point as irrelevant. Sustained. Ms. Abramson says, and so the first time he expressed to you a desire to do just tennis and not college was after his parents' homicide. Yes. Nothing further. The court says, I bet you want to leave. The witness says, I do. The court says, all right, you may. The witness says, thank you. Enjoyed it. Thank you very much. The court says, let us know when we can give you some more pleasure. All right. Who is the next witness? The next witness is going to be Amanda Geyer, who, go back to my notes here. Amanda Geyer is the Big Five employee who sold the brothers the shotguns, and she did testify for the prosecution in the last trial. We will read through hers and probably some of Valerie Hart's, or maybe combine the two of them in the next one. Valerie Hart is the real estate agent who I believe sold them the condos that they keep talking about, the ones that they keep referencing. So we're going to hear from both of them probably in the next episode, combining them because Amanda Geyer is a shorter one. So so we will get to it in the next one. So this was Mark Heffernan. I'm not sure if they call him again. I'd have to take a look at my notes. But at this point, we're making our way through week 3, and sorry for having to be the one to read this to you, but here we are, and we're working through it together and trying to figure out why this is so different, this trial, and why the brothers definitely did not receive a fair trial. And we know that they didn't, even though Nathan Hockman likes to pretend that the trial number two was exactly the same, and everyone just said nope. They just denied all of the brothers' narrative, and that's what makes them liars. I don't know. He's full of crap. He doesn't know what he's talking about. But anyways, thank you guys so much for joining me. Please don't forget to hit the like button on your way out. These videos don't get as many likes, so it would be nice if we could spread them, get them more likes and more views and whatnot, so that more people are aware of this case. Because I mean, people are aware of the case, but they're not necessarily aware of the differences between trial one and trial two, and that's really what I'm trying to get across by going through the entire testimony. We're going to go through it all because that's what you guys wanted. So we're going to go through everything, and we'll just go from there. So thank you guys again for watching. Take care, and I will see you guys in the next one. Bye now.